Any mention?
My lord, item number 11 on joint request, my lord.
Joint request.
Legally matter, Mr.
Lordship.
This is supplementary or main list?
Main list, Lordship.
Like, 11?
11, Lordship.
Yes, after 2 weeks.
Deeply. Also, I beg to mention item number 10.
Where's the appellant?
Lordship,
You inform them?
I'll inform the counsel.
You inform them first. Yes.
Daily list, item number 1. List, item number 1.
Wait, please, Your Lordship. Take the interiors. The main list. Huh? Also, what? And the main list hearing part. AM. Mabong. Kato kayo part. Acha, one second, Mr. Ghosh.
Yes, but
What about a fixed matter that mega traders? Is this a today? Your matter, your FJB
Yes.
number 7.
Mr. Saraf is leading, my lord. He is there.
Item 7.
Yes. So the fixed matter today, that's why, because that day we just accommodated Mr. Ghosh, so we said we just, if time permits.
No, there's a miscellaneous application that we have filed.
Excuse me, item 7.
No, 1 second.
Miscellaneous 170.
That day, but they're using a long people for fixed, because that's right there. Fixed matters first.
Hold on. There's a miscellaneous application 178 that has been filed. This is with respect to the deduction. Sorry.
Mr. Ghosh, we have to take up this fixed matter.
No
first.
problem, my lord. No problem. I shall read.
Item 7.
Where's the Advocate General?
No, the Advocate General is appearing in this case.
Who's appearing?
No, I'll be there just to assist him.
Yes. Who argued last time?
Advocate General here.
Yes, regarding 35
Yes.
section, yes. Where's Advocate General?
He's coming in. Well, the file is with him.
Think about 4 issues that are used for resolution.
Yes.
One was that the identity of the petition that there was notice by the commissioner was not fulfilled. Secondly, even if the court timely I think
I'm sorry, ma'am.
You continue with your submission today,
Yes,
correct?
ma'am. Actually, I thought Jorabat will take time, but I will argue, my lord, I have read.
No, we are taking up this matter as a fixed matter first.
Okay, all right. My lord, kindly see the case of the petitioner. It is based on 2 sections, my lord. Section 35 and section 39.
Yes.
So, the lordship will see the section 35 first, because your lordship has taken up the mega technical, item 59, my lord. And in mega technical, my lord, kindly see the pleading first, because your lordship will briefly recall what is their case before your lordship. The prayer, my lord.
Basic case is that if there's no proceeding notice on section 35, then the
yes,
39 cannot be
Yes, Lord.
cannot be exercised
Lord.
later on.
Yes,
That's all.
Lord.
Yes.
Kindly see section 35 and 39. This is the only case, my lord.
Where's the compilation of the
35 Act, your lordship,
Yes.
section 35.
Yes, periodical return and payment of tax.
Yes, my lord. Give me 35, this is not clear.
That's compilation, page 23. Yes.
Yes. Yes, sorry. Now, your lordship will kindly see periodical returns and payment of tax and interest. The tax payable under this act shall be paid in the manner hereinafter provided at such interval as may be prescribed.
Yes.
So, the requirement is to pay the tax as per the manner prescribed herein, my lord. 35(1) is clear. 2 is, my lord, every registered dealer shall in prescribed manner furnish such returns by such dates and on such to such authority as may be prescribed. So the returns are required to be filed by registered dealer, my lord, as per the rules. There is no confusion. Third is, my lord, any dealer other than a registered dealer referred to in subsection 2 shall, if so required by the commissioner by a notice served in the prescribed manner, furnish return in accordance with provisions of subsection 2. So 3 applies to
Any dealer.
any dealer other than registered dealer. I will say it will apply to unregistered dealer, my lord. So requirement of 35, your lordship has to see whether there is any requirement of notice under 35 to the registered dealer. if there is no requirement of notice to the registered dealer, my lord, then 39 can be independently invoked, my lord. Because the entire case of the petitioner is based on the premise that notice is required under 35. And now I have read 33 clauses, my lord. The lordship has seen that there is no requirement of notice. Before any dealer furnishes a return required by subsection 2 or subsection 3, he shall, in prescribed manner, pay to the government treasury or state bank of India the full amount of tax from him under according such return, and shall furnish along with such return receipt from treasury or bank showing the payment of such amount. Provided that a registered dealer, subject to such condition as may be prescribed, pay in the prescribed manner tax payable under the Act or any prescribed part or period which a return is required to be furnished under subsection 2 or 3 by such date as may be prescribed after expiry of this prescribed part of the period. My lord, this is regarding payment of dues, my lord. Provided further, a dealer may furnish return within the prescribed date without making payment of tax either in full or part, subject to such terms and conditions as may be prescribed. 5, my lord, if any dealer discovers any omission or any other error in any return furnished by him, he may at any time before the days prescribed for the furnishing of next return by him furnish a revised return, and if revised return shows that greater amount of tax to be done and what was shown in the original return, it shall be accompanied by receipt of showing payment of extra amount in the manner prescribed in formula. So if there is a provision of revision of return on the on discovery of the error, my lord, under 5. Now in 35, my lord, your lordship has seen there is no requirement of notice to the registered dealer. In all 5 subsections, my lord, first deals with requirement to pay taxes by the dealer. The 35(1) I will say is a charging section. My lord, tax payable under this act shall be paid in the manner prescribed. 35(2) is requirement of filing return by the registered dealer. My lord. 35(3) is notice to the unregistered dealer.
Yes.
34(4) is, my lord, the manner of payment, and 5 is the, in case of error, the dealer can revisit the return and can correct it and pay the differential amount, my lord. Now the confusion which is coming, my lord, is from 39. Kindly see 39.
Yes.
39. Scrutiny of returns, my lord. So it deals with the scrutiny of returns. Each and every return in relation to any tax period, my lord, kindly mark this any tax period because limitation is not there. It is any tax period because they have argued also, they have referred to
5 years.
5 years, 55, 57. Lordship, any tax, because the exercise is under 39, my lord. The entire exercise has been carried out by the Superintendent of Taxes under 39. So if each and every return in relation to any tax period furnished by registered dealer to whom notice has been issued by the Commissioner under section 35 shall be, this is subject to scrutiny. Yes, give me, this is shall be subject to the scrutiny. Shall be subject to the scrutiny by the assessing authority to verify the correctness of calculation, application of or correct rate of tax, interest and input tax credit claimed therein, and full payment of any interest payable by the dealer during such period. Now, the issue which is arising for your lordship consideration is the language or expression used. Notice. Under 35, my lord. Now, under 30, so this section, my lord, contemplates two kind of situation. One, it is covering those who are unregistered dealer, where the notice is required. And it is also covering the registered dealer without notice.
How do we read that into the section?
Yes, my lord. That is what, because lordship has seen in section 35, there is no requirement of.
See, section 35 speaks clearly about a dealer, registered dealer.
Yes,
and with regard to a dealer, that means notice by commissioner at 35. Correct?
Yes, my lord.
Now at 39. 30, still on 35.
Yes, my lord.
3 says any dealer, that means it doesn't mean registered dealers.
Yes, ma'am.
Now 39 says each and every return in relation to any tax period furnished by a registered dealer to whom notice has been issued by the commissioner.
Yes, Milord.
So that means that NB Sergeant said, you know, this,
so if there is
even for a dealer also, even for a registered dealer, notice will come.
because if 39, if your lordship reads as under, it contemplates notice to the registered dealer under section 35.
Yes.
39 says that to registered
It
dealer.
says so.
Yes, Milord.
But 35
35
doesn't say so.
35, there is no provision of notice to the registered dealer.
Yeah,
Milord.
exactly.
Yeah. So now how do we reconcile these two
How do you
provisions?
reconcile these two to say that it's maintainable, your
Yes, Milord.
action? Yes.
So therefore, how do we reconcile these section 35 and 39, which seem seemingly in? So my submission is, Milord, that this section 35 is very clear so far as notice is concerned.
35 is charging section.
35 is 1 is charging section, 35(2) is the return by the registered dealer, 35(3) is by unregistered dealer, Milord, subject to notice. So 35 contemplates notice only to the registered dealer, Milord. Notice to the unregistered dealer. Now 39 says that scrutiny only is pursuant to the notice to the registered dealer. Yes, Milord. Now here what I say is that, Milord, if 35 does not contemplate notice to the registered dealer, 39 to that extent has to be read down to mean that it is a note, because scrutiny can take place both in cases of registered dealer and unregistered dealer. Scrutiny can take place in case of both registered dealer and unregistered dealer. If there is no provision in section 35 to issue notice to registered dealer, Milord, 39 has to be read to mean that notice has to go to the unregistered dealer and 35(3), because that reading down your lordship will have to do in 35 and 39. There is some problem that I understand. And if I, Milord, if I take the argument of the petitioner, Milord, that there is no requirement of notice, and without notice you cannot scrutinize my return. In usual course, Milord, that means whatever return is filed by the petitioner, that will be taken as true, and there is no scope. So therefore, your lordship, for registered dealer there is a separate scheme, and 39 there is a, and in 39 there is a separate scheme for unregistered dealer, because 35 contemplates the notice to the unregistered dealer only. Because if the act does not contemplate notice to the registered dealer under 35, Milord, there is no question of the assessing authority or assessing officer issuing notice to the registered dealer, because in their usual course they will scrutinize the returns, because whether there is a evasion of tax or not, it has been properly reflected or not. So if your lordship will have to, this is the only issue which is there before your lordship.
That's the only thing. If we hire
Yes, and Milord, what I pray that if there is, because 39 has, there are so many errors in the act your lordship has seen. I have also seen that they have, while drafting, legislative
drafting, while
yes,
whatever they, when they, what
yes,
they call it, transposed it into the whatever they in the Gazette notification. There's so many errors, the typographical and clerical, and
yes, yes,
apart from
yes,
fundamental, like
now
what's happened in this section 39.
The issue before your lordship is that they have said that why did you scrutinize my return without notice? You could not have, you do not have power, Milord. I am really sorry to say, Milord, when you file a writ petition, Milord, in writ petition you do not disclose that notice was issued to me under 39. You do not talk about, kindly see 5 pages of writ petition, and this is a material concealment, Milord. This concealment itself, and you do not question the notice under 39. After the reply, you comply with the notice. It's not that, it's not a case of non-compliance, Milord. Kindly see, because in one of the matters your lordship will have to take serious view of the matter, Milord, because this is laying down the wrong precedent. Kindly see 59, Milord. I will
WC 59.
Read petition 59 of 59. No? Yes, yes. Now kindly see the list of date, Milord.
1 second.
It's a very short writ petition, Milord, and your lordship must take note of this, because what is being challenged before your lordship is so-cause notice or the process of assessment, scrutiny.
This consolidated amended writ petition is the one that we are considering.
Yes, Milord, it is this one.
Dr. Saraf?
59.
We're looking at this consolidated writ petition, correct?
The notice is 51.
59.
59, yes, I'll come. Yeah.
Yes, page.
Yes, 59. Your Lordship, kindly see, just see the synopsis. 3 pages, my Lord. The present petition has been filed challenging scrutiny reports and notices for curing defects in return issued by the Superintendent of Taxes. East so and so under section 39 of so and so, quarter ending so and so, the same being illegal without jurisdiction and violative of principle of natural justice as well as clearly barred by the limitation. As means, it is the contention of petitioner that in the present case no notice under 35 was ever issued to the petitioner company with a condition precedent for scrutiny of 39. The respondent number 3, in the absence of notice under 35 of the Act, most arbitrarily completed the scrutiny of returns in purported exercise of 39, and further the issued notice for the same directing the petitioner to cure the defects in tax returns within 20 days of said notice. Impugn action of the completing scrutiny return under section 39 without there being any issue of in 35 is not only illegal, arbitrary, without jurisdiction, violative of 39. But the same is clear violation of principle of natural justice. Is further contained that under section 39, scrutiny of return cannot be exercised at any time by authority's own free will, since the Act of 2003 provides a period of 5 years from the end of tax period as the limitation for completing assessment. Power under 39 of Meghalaya Tax Act cannot be exercised in expiry of limitation, since the scrutiny has been completed since notice has been issued purported exercise of 39 much after expiry period of limitation. 39 notice of subsequent notice pursuance are arbitrary, illegal, without jurisdiction, my lord. Now kindly see the list of date.
Yes.
10/5/2000. This is not relevant, my lord. Quarter ending at the relevant point, petitioner was the registered dealer with the Meghalaya value added tax and purchase certificate of registration issued by competent authority.
Where are you reading from?
I'm reading. I'm sorry. List of dates, my lord. 5.
No, which
Second column. Second column. First column is basically the name change of the company, my lord. 2. Quarter ending on 30th June 2 quarter ending 30th June 2017. At the relevant time, petitioner was the registered dealer under the provisions of Meghalaya value added tax 2003 and purchase certificate of registration issued by the petitioner regularly submitted its monthly return under the Meghalaya value added tax 2003 and claimed remission since petitioner was eligible for tax remission under Meghalaya value added tax. Now, my lord, the petitioner was surprised to receive a scrutiny report. Now, scrutiny report of returns sheet issued by Superintendent of Taxes, Clariat for period 2007 to 2017, whereby it was stated scrutiny reports of the petitioner company for period particular so and so 39 of the Meghalaya Value Act. Said report and the unit of petitioner was no longer eligible for tax, etc. So they straight away they come to the scrutiny report. No reference, no whisper that before scrutiny report they were asked to submit the records of the returns, and they submitted the records after 6 years. Now I put a question, why this material fact was not placed before your lordship? Because if they conceal the fact, they are approaching the court of equity, they are approaching this, and why have not they placed that pursuant to notice under 39, they have submitted the statement of account?
They have submitted that.
Yes, my lord. That's
not come on writ petition.
It has not been, not a single line in the entire writ petition. I will show, don't worry. Now, quarter ending, the petitioner was. No, I will read the whole. That is why I am reading, my lord. If you are going in 2017, notice has been issued, my lord, and you straight away you say that I am surprised of receiving it, my lord. I will read the entire petition. I went through the petition on my own, so that I can stand corrected if I am wrong. Surprised to receive impugn notice, my lord, 39. And now kindly see the entire petition, my lord.
Yes.
Lordship will not a whisper, my lord, not a single line. If my friend can show that they have received the notice and they have complied with this, my lord. And kindly see my counter affidavit, my lord.
They have not said anywhere.
Anywhere.
So, Sarath, have you mentioned anywhere in writ petition?
Only I am asking.
Can you kindly enlighten us on that point first? Just show us whether the submission is correct or not. Then we can proceed further from there. Then can you show from the writ petition where that has been stated? Page?
page 14 of the affidavit of opposition.
Yes.
Your Lordship will see.
Counter affidavit, my lord. Page, yeah, 60. Both is there
My
here.
argument is that what he is submitting to your Lordship and is
59 is also there. Yeah.
Respond number 3. By respond number 3.
Yes, my lord.
By the respondent number
Yes, report number 3. Just give me the.
3. Your Lordship will see that page 14.
Page 14, yes. Yes.
This is notice dated 27
Yes, yeah.
2017.
Yes.
Your Lordship and noted.
Yes.
And subject below your Lordship will see production of books of account.
Yes.
Your Lordship will
Yes.
With reference to the subject, you are ever directed reminded to produce in the office or understand the books of account noted for the period between so balance so assessment you also may not be clear.
Yes.
Assessment for the above period will be completed on the basis of judgment without the further investigation.
Yes.
None of the proceedings were initiated for scrutiny, not for scrutiny, for audit assessment. And 2017 the notice was issued.
Yes.
This is the production books of account for audit assessment.
Why have they not disclosed this in fact in the writ petition, my lord?
Please, Mr. Lawyer, you should not disturb the direction of the proper. It is your status.
Yes.
Why I have to not disclose and why I have to disclose that I will not disclose any relevant things and what connection with the position. But this notice part for the purpose of scrutiny assessment of production books and account. Your Lordship see section 39, there is no provision for direction for production of books and account. Now your Lordship further see the note sheet which I have given. But I have shown your Lordship the note sheet at page 19, 17.
So it is clear.
Have you lost your opinion?
Yes.
17.
This? Anyone?
This is a type of the note sheet. There are two positions in 19 and 17.
Yes. Returns scrutinized are section 39. MV Act anomaly found recorded in SR. Who typed this? Who typed this? Who typed this?
Is mirror which one?
Your
Please.
affidavit, who typed it?
This
Typing the typing from the order sheet?
return is scrutinized under
No,
39.
see 16. See page 16.
Returns scrutinized by 39.
One second,
Annual found recorded.
Another thing. Yes, just see 16. 16 and see what type on 17.
Yeah.
Returns
Yes, my lord.
scrutinized 13.
Anomaly they
Animal
are
found.
and they are writing animal.
What animal they found in the
Anomaly. It is clear in the line is anomaly and then
Who typed it? Who typed it?
Just act the website.
18.7.
21/7/2017, the regular paid 19/10/2021.
Yes. Yes.
Thereafter, in 2023, return scrutinizing the Scrutinizing Act also. Because this production book account was in pursuance to the notice dated 2017 for the purpose of assessment. When they found that the assessment cannot be done because it becomes time barred, they immediately were passed over to 39.
Yes.
There was no notice.
yes, Miller. I'll just now. May I start, Miller?
Yes.
May I
So understood,
start?
yes.
Yes, Milord. What
Understood, yes, let me continue, Doctor.
Yes, Milord. What I am saying, Milord, is that they have received the notice in 2017 for production of books of account. Is for scrutiny, Milord. How will I scrutinize the records when I don't get the? I have to see the records. What you have filed that I am liable to pay X amount of tax. Because I have produced so much, I have earned.
So your case is that
Yes.
you never had the opportunity to scrutinize.
So
After you issued a notice in 17,
Yes.
then you found
the after production of accounts, they produced the accounts. They produce the accounts or not?
now it depends 21.
21.
21 duly
Yes.
verified.
And
then the return
I'm not on
scrutinized
I'm not on
23.
that. No, I'm not on that issue, Milord. Why did they not say that there was a notice to them for production of accounts?
Okay, that part. only.
That I'm on that, Milord, because will that amount to concealment of material facts or not?
Yes.
Yet, because if because you are challenging my 39
Yes.
order, you are challenging my 39 order, and when you say no, production of account was relating to audit.
This is 27.4.
Yes, where is how do you say that it is an audit?
Okay, no, understood. Okay, please continue.
Yes, so Milord, this is a material concealment. You cannot camouflage by saying that, look, it was for audit and therefore I did not. Why did you not place this material fact before the Honorable Court? Is a question which they have not answered. They are trying to camouflage by saying that no, it was for 23, 22, 21. Is it not a material fact? I put a question to myself, Milord. Is it a material fact, Milord? When you are invoking the writ jurisdiction saying that I will not go in appeal, it is a violation of principle of natural justice. Your Lordship has seen in the entire synopsis what is their case. It is a violation of principle of natural justice. I have asked for your statement of account. I have asked for these books, and then thereafter I found the discrepancy, and you have complied with that also. Now, so therefore, Milord, to say that it is a case of you complied with this requirement now, and how do I read that this is an audit, Milord? The typed copy, Milord, your Lordship has seen?
Yes.
There is no answer, Milord. There is no answer why they did not place 27th April 2017. So, coming back to the main issue, Milord. On the legal, my case is, Milord, I will supply the material, the judgments on this issue, which clearly says that if you conceal material facts, and in my view and in my submission, this is a material facts for adjudication when you are complaining that principle of natural justice has been violated, no notice has been issued to me. That's their case, that no notice has been issued before 39. And if your Lordship will see
their case that no notice within the meaning of section 13 is issued to them.
Now your Lordship kindly see.
I understand has said that notice is issued, correct, but then after finding that anomaly and to the lapse of time they have invoked that you have invoked section 39 to overcome the latches on your part. That's
Yes,
the only
Milord.
thing.
So Milord, I have shown in 39 for any tax period scrutiny can be carried out, Milord. There is no limitation because if you are bringing section 55, you are saying it is audit. I have a power to scrutinize under 39 for any tax period. I have that power is there, Milord. And so far as notice is concerned, Milord, kindly see their averment in paragraph 11 of the writ petition. Paragraph 11 at page 17. And the last 5 lines of paragraph 11 at page 17. Since in the present case, petitioner company at the relevant time was duly registered under Meghalaya VAT Act, question of issuance of notice under 35 in the case does not arise.
Yes.
So I fail to understand what is their argument.
The argument is that it's on the procedure adopted. So basically it's on that. Procedure adopted. So whether you can avail of invoke section 39 to avoid limitation, whereas their argument
I'm not
that
avoiding
section 57 it precludes you from doing that, from examining any term, because you have delayed from 17.
Yes, my lord.
17 you've taken till 23.
Yes, my lord.
To finally take some action to say that this what we're doing is an action of section 39.
Yes, my lord.
Then you're hit by section 57. That is why you said 39. The 39, but then 39 again is couched in those words that it presupposes that a notice is served. So now you want the court to read down that requirement of a notice number 35.
39 says, my lord,
with 39.
39 says, my lord, 39 says, my lord, notice under section 35. There is no confusion about that 39, my lord.
Yeah.
The 39 says notice under 35, and 35 contemplates only notice to the unregistered dealer. 35.
Understood.
So, my lord, and my...
How can you happily construct all this, the entire
Yes, my lord. Now,
to come, to
yes,
say that your action they have taken is
yes, my lord,
totally above board.
Yes, my lord, as
in
per law,
consonance with
as
the
per,
act.
as per law.
And
As per, yes, my lord.
Yes.
So that the part is that if your lordship will say that no, before scrutiny you have to issue notice. You have to, the assessing officer is required to issue notice to registered dealer in 35. That is what they are trying to canvass and argue before your lordship, that please read notice to registered dealer under section 35 for starting the scrutiny. That part is not there in the section 35. They are trying to, they are arguing before your lordship, read something which is not in the statutory provision.
And you're asking us to read down what is there in statutory provision.
No, so therefore now
read. How can the court reconcile that?
In such a situation when the issue is where there is some incongruity, so far as adding something which is not there, your lordship may not be the legislative or the judicial tool to interpret. Reading down is a tool through which your lordship will reconcile, because my case is that and how it is relevant in our case also, my lord, if your lordship holds that no, for scrutiny under 35 contemplates notice, because contemplates notice to the registered dealer also. And then you can scrutinize the statement of accounts only after notice under 35. Failing which the assessing authority has no power to scrutinize the tax return. So that is something which they are asking your lordship to add in the section. Secondly, my lord, your lordship has seen that the books of accounts have been furnished by them there is a delay.
So of course, they were asked 17, they furnished in 21.
21. So there is a delay. So books of accounts have been furnished. Yeah. Delay is also on my part in
2 years.
39. What I have done in 39, what is it under challenge? Kindly see the fact also. 39, what is their challenge? Kindly see the orders also. That is notice, my lord. Kindly come to page 363.
Interesting. 362.
362, sorry, my lord. Now, if your lordship will see, what has happened?
Yes.
If your lordship will notice, quarter, the name of dealer, etc., quarter ending, Sri Manoj Kumar Verma, representative, appeared with books of accounts which duly verified, return scrutinized under 39.
Yes.
So, Mr. Manoj Kumar Verma appeared and books of and the scrutiny was carried out. What is being said? Audit. That is why Manoj Kumar Verma, I don't see any averment about this also in the entire writ petition, my lord. If your lordship, this is the order which is under challenge before your lordship, that I can't do it. So yes. So I will also argue alternatively, my lord, that there is a deemed notice books of accounts they have produced or not. Books of accounts have been produced or not, my lord.
Yes.
So what are we arguing before your lordship? Why can't they go under 45 before the appellate authority? Is it a case of complete inherent lack of jurisdiction, which the writ court alone will decide, not the alternative efficacious remedy, alternative remedy, my lord? Now kindly see the further, my lord. After scrutiny, return dealt in manufacturing of cement and cement clinker. Return scrutinized against amount produced, turnover as per accounts produced was found so and so, which tallied with the return submitted. Purchase and sales were voucher for record in detail. ITC claims found at so and so, same is supported, proper document, unit has made 22% of aggregate turnover, a stock return furnished so and so, has revised so and so, ITC claim under 11(9)(c) of Act and availed only of so and so, same is allowed, the unit is no longer eligible under the Meghalaya tax remission scheme up to 2006, hence the scrutiny was completed as under, my lord. These are the and the anomaly found, non-payment of full amount of tax and interest. And issue notice under so and so, my lord. So they scrutinize the records. So is it not a case when we are asking for records? If their argument is notice, that should also be treated as notice. Ultimately, your lordship is weighing the equity in the jurisdiction, where the tax evader is trying to evade the tax in the name of technicalities.
Please don't this is not proper.
Is it? I will. I'm sorry.
Right.
I stand corrected. I stand corrected.
Avoid.
I'm
Avoid
sorry.
taxes.
So
Avoidance or illegal.
Sorry, avoidance of tax, my lord. I don't want to go into all those issues, my lord. My submission is I stand corrected, and I say sorry to Mr. Saraf if he. So the issue is that if this is a case of tax evasion. Tax evasion is detected after, I can say this much, my lord.
Yes.
If there is a tax evasion is detected after scrutiny of records, would your lordship allow a person who is evading the tax to take a shelter that 39 requires notice? You have notice, you produce the accounts. Did you raise the objection that I will not produce the account? No,
Any other submissions? I mean, this sum and substance.
This is the sum and substance, my lord. This is the sum and substance, and 39 your lordship will come again. 30 because limitation. Because
what about the arguments on
55?
55.
Yeah, lordship, kindly see 55. 55. Kindly see 55 also.
Which was it? No? Yes. Where's the act?
And alternative is 45. Appeal is.
Yeah, the decision is taken by rate.
Lordship has the audit assessment.
We can use it. Where's that? Sorry. Where's that? That's the one. Oh, yes.
Lordship, your lordship will see the compilation, my lord.
Yes.
There is.
55.
Yes, my lord. Audit assessment.
What do you pahata? The UPS ka. Kau check ka tu? Two from two you. Computer channel ta. Sorry.
No.
50. Yes.
This is correct. This is correct.
Yes.
55. Audit assessment, my lord.
Yes.
Where a registered dealer has failed to furnish any return under subsection 1 of 35.
Yes.
What is the requirement, my lord? First, registered dealer has failed to furnish any return.
Yes.
Subsection 1 in respect of any period. So first requirement is that there is, so is their case that they have filed this return, my lord. It's not a case which is falling under 55A.
Yes.
55B, A registered dealer is selected for audit assessment by commissioner on the basis of any criteria or random basis. So have I invoked 55, my lord? I have a power under 39. I have invoked 39. I did not invoke. How are you putting me in section 35? And 39, if your lordship will see, because first they have to show that I invoke the power in 55. The lordship, their challenge is prayer is 39 is I can't issue.
Yes.
And only ground is that I have not issued notice to them. Yes. 39 is not talking about any period of limitation. And each, your lordship has seen in other matters also, if the limitation, my lord, each section is separate period for limitation. In 39, challenge is before your lordship is 39 only, not under 55. 39 is only only ground, my lord, is that I have not issued notice. The lordship has seen any case, my contention is that no notice is required. And even that contention is not accepted, my lord. They have produced the books of accounts and scrutiny has taken place, my lord. Can't they go before 40 under section 45, my lord? The appellate authority, appellate authority is which section? There is a appellate authority, appeal 65. So there is a procedure laid down, my lord. There is a procedure, revision, review. If your lordship will see the yes, I'll read. Appeal. I'll read. Any dealer, my lord, appeal, revision, and review. Any dealer may, in the prescribed manner, appeal to the prescribed authority against any assessment within 45 days of such further period as may be allowed. Yes, my lord. Against the assessment within 45 days. So appeal is against the assessment. What my learned senior counsel is saying, my lord, that it is against, appeal is provided against the assessment order, not against 39. That is, yes. Am I correct, Dr. Saraf? That is what you are trying to say? There is no appeal under section 39. So the question is, if there is no appeal under the section 39, whether writ petition can be filed against 39, order of 39. And if their case is that it is there is no appeal against 39, my lord, so they can't put me in 55. Either I'm in 39 or in 55. If it is in 55, appeal will lie. I can't be put in peril in both situations, my lord.
Yes.
I can't be put in peril in both situations. And then, my lord, there are sections which say that the straight away suo motu power revision is there, section 66.
Yes, that's true. By the commissioner.
Yes, my lord. Then there is a provision for review of the order. Then there is a further appeal to the High Court, my lord. Then there is a provision to the appellate tribunal. Then there is a provision of revision of High Court. But 39 is, my lord, at the stage of scrutiny and direction to file correct return. Your lordship will see, because they have, what is the direction? So I have power to do it, my lord. How are you invoking section 55? 39, your lordship, kindly come back to 39. My entire case is based on 39. Each and every return in relation to any tax periods furnished by a registered dealer to whom notice has been issued by the Commissioner under 35 shall be subject to scrutiny by the assessing authority to verify the correctness of calculation, application of correct rate of tax, interest and input tax credit claimed therein, and full payment on interest payable to the dealer during such period. If any mistake is detected as a result of such scrutiny as made under the provision of subsection 1, assessing authority shall serve a notice in the prescribed form on the dealer to make payment of extra amount of tax along with interest as per provisions of this Act, if it is payable by a date specified in the state, if the Commissioner discovers any error or omission in any return furnished by dealer or by has reason to believe upon information otherwise dealer has furnished a correct statement. Incorrect. So, my lord, kindly see now, kindly come back to my notice under 39, but because that is a challenge 363. $362 million.
Yeah, please.
Your Lordship will see the unit no longer eligible under Meghalaya tax remission scheme under 2006. So unit is asking, it is taking a credit, my lord. So this is the error corrected and notice has been, and that is under 39 notice. Your Lordship has seen this is the order under 39 after scrutiny of the records. And those submissions of the records of 2017, which was submitted, I asked in 2017, they submit in 2021, they say it is an audit assessment. Section 39 clearly says that in each and every return in relation to any tax period. So how do you bring section 55 in this period? I have power under 39, so I have exercised the power validly and legally, my lord.
Okay.
And I have given the notice to them that look, this is the error, and they are silent on this error. How have they availed this the tax exemption?
One other thing, just coming back.
Yes.
Now this is you mean to say they made no averment with regard to this page 362 at all in the petition?
Yes, my lord. My friend,
the authorized representative went the books of account before the authorities.
Yes, that is not there, my lord. I checked. I will read only 5 pages of writ petition. I may be wrong, my lord, but I have checked it personally. My friend can show me from the writ petition. I will get a stand corrected, but I did not find, my lord. I did not find. And this is a serious matter, my lord. In one of the cases, your lordship will have to take serious note of the matter. That too in cases where the tax matters are involved, my lord. Because each step is very crucial. And your lordship has bestowed sufficient time in examining the provisions.
That is all?
That is all I have to say.
Any reply, Dr. Sarah?
Yes, sir.
Yes.
I think, first of all,
Yes. 35(1). Yes. Why?
It is 65 of the assessment, which is the charges. Charging section is different, but the charge is related.
Yes. One second. One second. 5. Yes, levy.
Subject to the Proceedings Act and the rules limited charge tax of the general sales which specified in the schedule of charging provision 1 by which a charge is related. And the specified one is the necessary provision for submission of the return system. So 35 is not a charging provision.
Yes.
Now, my friend, I come to the separation because that is the last resort of the all other things fails. I will first of all the submission announced by the revision that 639 will be down.
Yes. That you have to reply. Yes. Yes.
That a provision can be down only when the constitutional validity of the provision is challenged. And the court finds that if the section of provision may be unconstitutional, and to save the provision from being unconstitutional, a provision is down to get it into conformity with the law.
Yes.
The court never reads down the provision when a release of the provision is not under the challenge.
Yes.
And the state making a submission for the lawsuit that the provision will be laid down, that is unheard of. Now,
Yes.
but I will also be available. The interpretation of the taxing institute. The interpretation of the taxing institute is the strict interpretation of the taxing institute, as the words whatever have been used in the statute. If by the strict interpretation of the taxing institute, if one falls in that statute, it is okay. If it doesn't fall in that provision of the act, then it is out. There is no entailment equity in the taxing institute.
Correct, yes.
These are the very simple principles that equity, entailment, etc. are outside the interpretation of the taxing institute. Now, there, my friend is saying that there is a lacuna. Now, if there was a lacuna, it is not for the court to remove the lacuna, but it is for the legislature to step in and to do the needful.
Yes.
My lord, as you are remember the famous saying that in the taxing institute, the court can at best arena of the villages, but cannot alter the materials of which the court is moving.
Yes.
Your lordship, by exercising the powers and by interpreting the taxing institute,
Yes.
in my humble position, cannot say that these words are not necessary because they don't make this in 35. That is not within the analytical powers of this board. Now, we have to interpret section 39. Section 39 says that a person to whom a notice has been issued by a commissioner.
Arrow 35. Yes.
That is under section 35. Now, 35 says that notice can be issued to an unregistered dealer who was not submitted in Miscellaneous. So, only thereby a notice cannot be issued to a registered dealer. I agree with that. Just like my friend was reading the paragraph. In the paragraph, I only said that section 35 the notice can be issued to a person who has not submitted a return, but I am a registered dealer. That's why section 35 will not apply to you. Further, I said, in the same paragraph, the last line, 4 lines is divided, that section 39 contemplates issuance of notice in section 35 by the commissioner, and since the same notice would not come to issue to the registered dealer, the section 39 power cannot be invoked.
Yes. That you argued earlier on, Doctor. Yes.
I was just replying.
Yes, yes.
35 to 39, and my statements in the
No, that is your case. Your whole basis of your case is on what you submitted just now. That we have noted in the last hearing.
Well, that notice you also see kindly. That is for assessment. And the assessment
Only that coming to another point, which that is the thing that your writ petition is completely silent on the fact that you had received whatever kind of notices, but a notice, and yet produced the books of account before the authorities.
My lord, I am sorry to say, that if I have to state something which is irrelevant and which is not connected with the case, a notice which was issued for assessment, and the proceedings for our scrutiny, and I have to state from my birth whatever statement.
Not from your birth. But this is germane to the issue. Yes.
No, that is not general at all. Because
Okay, we'll not argue with you, Dr. Saraf. Please continue. Yes. Yes.
well, I'm not saying that I have my humble submission only before Lordship.
Yes.
This is that because SSC are always to be humble. It is our state mighty who can say anything, but I cannot say I have to be very humble. My submission will also be that material facts are the facts which are necessary for the purpose of adjudication of the liquidation.
Yes.
Now, in the Contempt case, the adjudication is whether 39 hours can be invoked or not. And the lawsuit is the notice was there. That notice
So ancillary facts or ancillary facts, no matter in your submission, is not relevant. Also, need not be referred to.
well, all of these things are referred to from the beginning. I taken a year, and what has happened, I have to refer everything. This notice was not by the commissioner, this notified by the assessor authority.
Right.
So that the notice is contemplated by the commissioner. You don't need notice for the issued by the commissioner. I was going to mention it in the requisition. The notice was by the student access.
Okay. Yes.
And the student access notice cannot be constituted a notice section number 5.
Yes.
Now, you also again for the sake of repetition also looking for Lordship, and I told it.
Yes.
Sometimes I also repeat it, but
Yes.
Lordship had denied. It is mentioned for the purpose of assessment. Now, assessment of instance are all the different. They have to successfully there. Your Lordship is number 5.
Yes.
That is for assessment.
If no return are furnished by registered dealer, it's a case of no return.
So 45 is assessment.
Yes.
There are section 46.
Yes.
Assessment without judicial to the prosecution for the year of offence. Then prosecution section 55 that is standard assessment. Then 55 audit assessment. Now I also managing that notice was issued by the assessing authority. What was the purpose of making of the assessment?
That was made in 17. No, 17 was notice. Then 21 the books of 21 the 23 whatever. There are 3 dates. 17, 27 4, 2017. Yes, and the notice was issued. Yes.
And then 21 the production of book account.
Yes, but the 21 punishable account. Yes.
Now that production of book account cannot be prior to issuance of notice.
Yes.
When the scrutiny was done, 2021 the book accounts were produced in pursuance to the notice issued in 2017.
Yes.
When the assessing authority found that the assessments have become barred by initiation.
Then they made it into 39.
Then we jump on section 39
Yes.
and mark the ordinance in 39. Secondly, scrutiny is to be done on the basis of the return and the income tax law. When the returns are submitted, then a indication comes about the calculation and the that is not about the book account. Whenever the book of accounts are directed to the rules, that is for the purpose of assessment. Scrutiny means you will also see the section again, section 39, just for the sake of although I am certainly also.
Yes. Yes.
Section 39, each and every return in relation to the tax period furnished by the related dealer to whom a notice and issued by the commissioner shall be subject to scrutiny by the assembly to verify the correction of calculation, application of correct rate of tax, interest and input credit claimed therein in the return.
Yes.
He has to see the return and see that whether there was a mistake or not. This is not something which is equivalent to assessment that problem of the book of account and then I will make assessment.
Yes.
That's why I submitted a document that under the use of the powers of Section 39, what the system of the done is making an assessment.
Yes.
And that's why from the very beginning I submitted that there is no time limit prescribed for Section 39 of the Act.
Yes.
But I submitted on the basis of the decision of the Archival Data that when the no time limit is prescribed, then the assessment has to be done within a reasonable period, and the reasonable period was constituted to be a period which is the maximum limitation provided in the Act.
Yes.
And in this case, the maximum period of
5 years.
5 years.
Yes.
So in that time, I submitted for your lordship, I never submitted that it is barred by limitation by because of the 660 of the Act. No.
It is there in the requisition.
Yes.
Now, my learned friend has not given reply to the question of the delegation of powers.
Commissioner.
By the commissioner.
Yes.
My lord, the Act specifically
Lord,
says
I will say that I didn't find single line in the entire petition
On delegation.
on delegation of power.
my lord, I saw, my lord, that when they have issued a notification that act has been delegated and a lordship declared the constitutional judgment of the Supreme Court, wherein it is said that statements made in the rejoinder affidavit are also a part of the pleadings of the requisition.
It's not the ground urged by them, my lord. There is no ground, my lord. How will I meet in rejoined? It's not a ground urged by them.
How I can
And I request my friend, my lord, I have the lordship kindly, when he is talking about the section 55 audit, my lord, he should also place section 85, my lord, where the power is already there.
There will be
84.
Be unending this matter with.
No, 80, because this is a new point. 84, my lord, section 84, 5.
Members admission was submitting anything like the appeal was there, 1 year was nothing. I did not point it out anything. I gave full complete
Liberty to argue. Yes.
hearing to the learned advocate.
Yes.
Now I am not so learned like that learned advocate.
I am also not learned. Dr. Saraf is more learned, my lord. Dr.
And
Saraf.
that learned advocate, I think, is very kind enough. He gives patient hearing to everything. Let me also, for my satisfaction, make my submissions.
Because what is being argued, which was not argued in the min, rejoinder, it's a rejoinder, my lord. If new point is being
No,
argued,
what, but Dr. Saraf had argued that regarding delegation of powers also. But then your reply is, since it's not a pleading in the petition,
Yes,
so deserves no, does it?
yes, that is what I have said. Because
Befits no reply.
Because they have not, because then I have to, if there is a ground, my lord, I would have placed all material showing that everything has been done. Where do I get opportunity to rebut that? Lordship, the basic rule of pleading is that you have only two grounds, my lord. Two grounds, my lord. Only no notice under 39 and barred by limitation. Your lordship has said these are the two things.
You are so busy. That your respected counsel is not giving you total full instructions. Miller in reply further was filed to my dealing with the point of delegation. Miller, it is not so that the I am just coming as a surprise. When I read, they have given a reply. And they have also issued the notification around the afternoon. So, not so. That's something that I am arguing was not there. I raised the point in the agenda and they have given a reply.
Yes, okay, continue, yes.
Now, I am telling you, if some person or authority is invoking the powers which has not been conferred on him, that point can be raised at any stage of the requisition. And that point was raised in the decision and they have dealt with it. They have not been able to show that there was any notification issued by the commissioner delegating the powers to the assessing authority. No power.
Yes.
If I am a tax payer, then I also have the same law.
UPS.
The state also cannot partake the characters of, I will not use the further word,
Yes.
the Supreme Court the idea observed that the persons who are interested with the administration of the tax laws are supposed to know the law in full, and if they don't know the law and they administer it, they must suffer.
Which is the citation? You kindly, can you provide it? Yes.
I will give a copy of the personal authority. I'll send a copy of
Lord, in judgment which is cited in rejoinder, my lord, that I need to deal with that also. Because if you cite in that is the basic requirement, my lord. If my friend is relying on some judgment in rejoinder, my lord.
I think we have to streamline. I think if we have to get anywhere now, where we were under impression that today is a fixed matter, we have to streamline now. What the parameters of arguments, exactly that Mr. Advocate General, with regard to exactly your replies, to the pointed questions.
I'll put in my note.
Basic core issue is 35 and 39.
Yes,
then the side issue comes to whether enumeration 55, so on and so forth. Then it comes to whether it can be read down. Now it comes to whether the powers exercised by the competent authority. Those are the things.
These are
that
three.
And that is on the factual aspect.
Yes,
then the other aspect, whether they have suppressed which is material.
I would say that is the first point.
That is the first point that you've taken.
This is the first point, madam. That is the first point.
Natural justice have not been violated.
Yes, madam.
Even now in matters of commercial, the law developed also. Natural justice, how it's applied also will differ from case to case.
Yes,
so that is a different aspect.
Madam. Yes, madam. That I quite.
Yes.
That in case I succeed, I'm saying in case I succeed in going to 539, I will not place on the delegation powers.
Because, my lord, they are the beneficiaries of the orders passed by the.
I must say actually, I think I am giving I will not like to put the state in trouble because the point which I am raising of the delegation powers may have a far-reaching effect on the state. The provision must understand it that will have a far-reaching effect on
other cases, on other assessments.
Not other assessments, not all assessments.
All assessments is made. I mean, not regard with this with your company, but with all the other.
So, Lord, if the whether delegation, if I would have asked.
No, okay. Let him finish. Let him finish.
I am submitting that this is only my last resort, and it is not so. That even if I win the first case also, I cannot challenge the delegation. I can challenge further the delegation also. But I am saying that I am not interested.
Either you take the point, I am not shying away from the on the delegation, my lord, but you have to take the point in the writ petition, my lord. You can't come by and then I will deal with this, and I have already dealt. My friend has shown me those delegation of powers are there, my lord. I will deal with it.
He is threatening you.
Yes, we have done it.
That's all the thing.
His apprehension.
Threatening that also is putting, that
To concede on
for the court.
To concede on 35 and 39, my lord.
No, yes.
And 2017 is not a notice. He says that it is not a notice also under. If it is a notice,
Was it?
I only say that in case I succeed, in case, I never said no,
Dr. Saraf, that what they call it, that's a loaded submission.
it's loaded submission.
The bullet is there in the gun, you're not firing it. That's a load submission. That in case, then I'll use this gun. I'll use this gun on you. If, I'm threatening you with my gun, and if you don't succumb to my threat, then I'll release the bullet. That is what you're doing.
I think that I can persuade to lawsuit, and if in case I succeed, I will be in the favor of interest of the state. I will never proceed with the second.
Exactly, holding a gun, and you say that if you don't hand over, then I'll press a trigger. That is your submission.
I never do that way.
No, but I'm just giving a illustration.
One day, whatever your office is saying is correct.
Yes. Yes. That is all, Dr. Saraf.
Also, you noted everything.
No, you should file your notes.
Yes, my lord.
That is all.
Will.
Yes. Yes. Dr. Mosika, what about your matter?
I'm adopting submission.
Yes.
The only thing
In their case, their case is to petty bad, my lord.
as a parting thing, only one submission I'll make, my lord. What learned AG is saying, my lord, there is something to be read down, my lord.
I'm not saying just to be read down, to strict.
Yes.
There's a clear inconsistencies between 35 and 39, my lord. Now, something has to, if your lordship wants to do something to bring this in harmony, my lord. So what is the best possible way, my lord? Well, kindly come to section 30. It says, each and every return in relation to any tax paid furnished by a registered dealer, to whom notice under section 35. My lord, this registered, it has to be unregistered, my lord.
Yes, that's one. That's one.
So it has to be, if your lordship interprets or reads in that manner, my lord, this word has to be read as unregistered.
It's so unhappily worded.
My lord.
It's so unhappily worded that it envisages a notice when it talks about you're only concerned with dealers only.
So, 39, if your lordship says that it should be
should have
read as
been another
unregistered,
section, where for registered dealers, as you've done in 35,
Yes, ma'am.
delineating clearly the dealers and registered dealers.
Yes.
Same thing you've done 39 also.
39, my lord. Because for registered dealer, there are other mechanisms. Or tax audit is there, audit assessment is there.
It's
income
totally
escaping
it's a
assessment is
different
there.
regime altogether for registered dealers and for dealers. Dealers are unorganized. You come on a sector, how does the
And they
taxing
have-
authority,
and we have to issue notice to them, bring
what you call it, bind them to find the return.
What I'm submitting, what has to be read down in a different manner, not in the manner Advocate General is saying.
For reading down also to repugnancy, but then other reading down is whether to make the act workable or whether what is the objects of the act, whether it's being frustrated.
Exactly.
By the way, that is the entire objective of the act is being frustrated by the certain provision.
So, 39 has to be read as unregistered, my lord. If that is read as that, everything falls in place.
Yes,
84(5) is also where which we can ask for records, my lord. Section 84 subsequent.
you make your notes.
Yes, I'll place it.
Then they'll have a deal of argument if you say that you bring other supplemental provisions.
No, this is only
we thought
39 only.
What 35 and 39 only.
Yes, well, 35,
and we will
39,
whatever
39,
do our
35.
best. We will
Yes,
try to
yes,
interpret
yes,
it.
And
35,
limitation also, my lord.
Limitation secondary. So that yes, actually the Justice Kurshi judgment.
Yes, my lord. I will also deal with that part, my lord, in my note. I have seen it is not at all applicable in our facts of the case.
Yes, then you
By
place your
submission,
notes
yes.
after 1 week. 1 week or sort of.
After
Number? Yes. No, what points are different?
which, what is the difference between?
Which case? 60.
60. What is the difference in 16?
Almost same.
Then it will follow. If we render a judgment in this matter, that means it will cover your 60 also.
It will cover 60 also, my lord.
We can't allow 60 to become a review of 59 in case your case is not allowed. It's like that. No, Dr. Saraf, we can't have that. If it's on the same, basically, substantially, it's on the same road. Yes. Is that correct, Doctor?
Because what was argued, I heard on YouTube and everything, my lord, that was in respect of 59.
Yes, Dr. Motka, is it?
But I'm not there. My case is covered with earlier.
You're not here, okay.
Your lordship, these sections segregate because what I see that there are some other sections, but the principle is decided that we will have some.
I WC 59 and your matter is WC number 402. That's your 402 of 24. 23 and 59 24. Matter hearings concluded. Parties are permitted to file their written notes by
10 days, not 10 days. We'll do
by 2 weeks. Yes, we list it, but if you don't list it, the notes won't come. Yes, yes, list after 2 weeks. Yes, and 60 on the prayer of the council of parties. This is matter after 3 weeks. Yes.
Only for submission, my lord. Only for submission of notes.
submission.
Our notes start again.
Yes. Yes.
Grateful, my lord. Grateful.
Thank you. Thank you. Yes. Now, okay. The 11. Number 10, who swore adjournment? You have no objection? Why not there in the morning when the mention was made?
I was under the impression that my senior will be coming and conduct the hearing,
Okay.
but then due to
After
some
2 weeks then,
personal
yes.
difficulties.
Supplementary list. Item number 1.
May it please the lordship.
Yes, sir.
This application we have.
Case is there, yes.
Yes, Miss Case, my lord.
They'll have to file a reply to that.
They may do so. It's staring at the face because they say that apparently there is no interim order. Therefore, they have done what it is. It's on the face of the interim order. And respondent number 2, I think 6. Sorry, respondent number 7.
Yes.
Respondent number 7, who is the excise department, and respondent number 6, who is the additional commissioner. They were in the know of it. So I will leave it at that. I just wanted to point it out so that it's on record. And we can spend time on this, my lord. Now coming back to the main matter, my lord.
Yes, we'll pass orders on this one. Yes. Miss Case WC number 178/2025 in so and so. Stop. This Mrs. application has been filed, bearing on record the fact that though interim orders were operating, as was noting, the respondent number 7 has taken coercive action against the writ petitioner by where is that? Where's the annexure? By where's the relevant annexure?
Yes, my lord. Page number 31, page 30, annexure 6. is where we wrote to the state, and page 31 is where they reply.
Yes.
Annexure 7. And kindly see the third last paragraph.
It written that as submitted when interim orders were in operation, a debit has been made from the it's from your account.
Yes, my lord, from my
The account of the writ petitioner. Stop, Mr. Sincon, let to file affidavit. Yes. Yes, come to the main matter.
Yes, madam. And on the last date, on the last date, my lord, I had made 4 submissions, just to summarize. That the meaning of the word concession cannot be lost sight of. This is a concession agreement. There are licenses and rights and privileges that are conferred on me, basis which I do what I do. That's the first thing I had mentioned. I'd also mentioned the recent decision of the Supreme Court, where their lordships have said that when you are acting as an assignee in this kind of transaction, you are discharging public function.
Yes.
And the public function is to satiate or meet the right to life, right to movement in terms of access to road.
Yes. Yes.
That's the second thing I said. I also said that please do not pair me with a construction contractor, because construction is an independent thing altogether.
That is yes, that submission, yes.
Right. So these are the 3 things. Fourth, I said I don't do works contract because there is no transfer of property in goods during execution of the work. I took the example of construction of a flat and purchasing a flat. From there, my lord, I had to submit the dictionary meaning of the word concession that my lords had requested me to bring to fore. Lord, page 1 is from Advanced Law Lexicon. At page 2, right column, the very last definition, concession.
Yes.
Concealing a thing or conceit, we need not be bothered about. A grant ordinarily applied to a grant of specific privileges by government, a special privilege granted by a government, corporation or other authority. The right granted by the host government for a private company to undertake an otherwise public sector project and operate that project over a period of time. This is the public function, my lord. The definition also says exactly what the Supreme Court had also alluded to. Then kindly turn to the next page, page 3. Concession agreement. The third meaning is in bold.
Yes.
On the left column.
Yes.
The agreement with a government body that entitles a private party to undertake an otherwise public service. Clearly, therefore, what I'm doing is a public function, public service, and therefore I'm satiating the need of Article 19(1)(d), right of access to road. Then concessionaire is also defined. Concessionaire means a person with whom an agreement has been entered into under Section 80 of the National Highway Act. So that is what it is. Concessionaire means a party which has entered into an agreement called concession agreement with a project authority for developing infrastructure. That's the other one. Then my lord turns to Oxford, which is at page 4. Page 4 is Oxford, and at page 5 on the right column, Lord, there is a definition of the word concession, which is the item 3. At the very bottom, at the end of that paragraph, there is a serial number 4 in bold. Lord, see that? Item 4.
Advantage.
A right or an advantage that is given to a group of people, an organization, etc., especially by the government or an employer. And the illustration is Bolivian government has granted a logging concession recovering 22 hectares of land, etc., etc.
Yeah.
Then my lord turns to Black's dictionary, which is at page 6, and at page 7, the very third meaning. My lord has that?
Yes.
Concession, a government grant for specific privileges, a voluntary yielding of demand for the sake of settlement, rebate or abatement, we are not concerned. A contract in which a country transfers some right to a foreign enterprise, which then engages in an activity such as mining, contingent upon state approval and subject to terms of the contracts. All of these definitions therefore clearly say that this is an area earmarked for the government or the state.
Public function.
It's a public function. That's the import of that. Correct. That's what it was, my lord. Now, my lord, I had also mentioned that, if my lord recalls, that after 20-30 years, the end of the concession period, there is a conveyance that gets executed for transfer of the whole thing. Therefore, it's the transfer of an immovable property. Therefore, you cannot say it's a contract where there is a transfer of property in goods during execution of work happened, as it happens in chattel collateral. There is a provision in the concession agreement which I wanted to take my lord through. If my lord takes Article 47.4, which is page 307 of my petition.
One second. 307.
307, Article 47.4.
Yes.
Yes. At the foot of the page, 47.4.
Depreciation.
Yes, depreciation. For the purposes of depreciation under applicable laws, the property representing the capital investments made by the concessionaire in the project shall be deemed to be acquired and owned by the concessionaire. For the avoidance of doubt, the authority shall not in any manner be liable in respect of any claims of depreciation to be made by the concessionaire and the applicable laws. Clearly showing that the capital investment, which is all that money that I put in to create the project highway, project asset, all the bridges, culverts, machines, everything else that goes into making a project highway, it clearly says property belongs to me, deemed to be acquired and owned. And if the subsistence of ownership happens even after completion of the construction, then there was never a transfer of property in goods during execution of work.
You remember it's 1 rupee.
Is yes.
30 years.
No, that 1 rupee is the concession.
Concession, yes.
Then this goes to show that my ownership over the project assets vests in me, continues until the transfer happens at the end of the 30th year. Then my lord comes to 38.5.1, which is page 291. Page 291, 38.5.1. Divestment. 38.5.1.
Okay.
The concessionaire shall bear and pay all costs incidental to divestment of all the rights, title and interest of the concessionaire in the project. So there is a title in the project that I have in favor of the authority upon termination, save and except that all stamp duties payable or any other deeds of document executed by the concession in connection with the such despite divestment shall be borne by the authority. Clearly, like a conveyance happens. The seller says that the buyer says, you don't pay the stamp duty, I will pay the stamp duty. It's a classic case as it happens in any conveyance. The seller never pays the stamp duty. Again goes to show immovable property being transferred to a conveyance. No question of transfer of property in goods during execution of work. Then my lord, page 216, 7.1. Representations and warranties by the concessionaire, 216, my lord sees that. Then the next page, clause N, which is the second last paragraph of that page. My lord has that, clause N.
All is right.
All its rights and interest in the project highway. I asked myself the question, what kind of right, what kind of interest will a contractor ever have? Contractor only has a right of receipt of payment. Unpaid seller's lien. That's the kind of thing. These kind of rights, all the rights and interest in the project highway shall pass to and vest in the authority. Clearly, it's talking about a sale of an immovable property. That is the purport of a conveyance. And on transfer date, free and clear from all liens. Lien can be created by whom? The person who owns it. I can't create a lien on somebody else's property. Clear from all liens, claims and encumbrances without any further act or deed on its part or that of the authority, and that none of the project assets shall be acquired by it, subject to any agreement under which a security interest or other lien or encumbrance is retained by any person, save and except as expressly provided. So these 3-4 clauses makes my respectful submission, makes it abundantly clear that contrary to what learned counsel from the state was saying, there is a works contract. It is not so. It's a sui generis contract involving concession, divestiture of property, immovable property, and that therefore there is no question of any tax on that. Now that brings me to, kindly take the CGST Act.
Yes.
Just to put a context of what I'm going to submit. In the pre-GST era, a works contract had 2 features.
Yes.
Supply of goods on which state could levy sales tax,
Yes.
and provision of service on which center would levy service tax. So there were 2 separate aspects.
Yes.
So far I have said it is not a works contract because there is no transfer of property in goods. My lord may ask me a question, what about the service aspect of that? That will be a logical sequitur to the question. I have to deal with that. May I request my lord to take Schedule 2 of the CGST Act? I could help my lord trace that because the schedule is at the end of the page. Can you tell, you have the book? You can tell the page number, otherwise my lord will. Section 174. Below the provision ends at section 174. I was fearing that because
Yes.
it's so voluminous, this statute.
We are used to that, Bhagwash. All page.
I wouldn't know the page, my lord. That's the trouble I had. Section 174 is where it ends. Do you not have the act? You can just pass it on.
Yes.
Well, has that? Section 174?
1 second. Integrated. Yes. Getting there. Wait 1 second. Yes. Schedule 2.
Yes, my lord. Schedule 2. May I read what Schedule 2 says? This schedule is under Section 7. Section 7 defines what is a supply. I need not trouble my lord with that. Section 7 defines what is a supply. This schedule says activities or transactions to be treated as supply of goods or supply of services. So this is a deeming provision that some things will be deemed to be service, something will be deemed to be supply of goods. This is the purport of this schedule. May I request my lord to take a look at entry 5.
Supply of services.
Supply of services. The following shall be treated as supply of services, namely, clause B. Construction of a complex, let's see that clause B. Construction of a complex building, civil structure, or a part thereof. Civil structure, my lord, would include a road, bridge, all of those things will get covered under civil structure. Construction of a complex building, civil structure, or a part thereof, including a complex or building intended for sale to a buyer, wholly or partly. So anything of this kind is a supply of service. But the exception is, this is what I wanted to lay emphasis on.
Yes.
Except where the entire consideration has been received after issuance of completion certificate, where required by the competent authority, or after the first occupation, whichever is earlier. The purport of this is, if I am a construction contractor, assuming, well, are not agreeable with what I am saying, I am a construction contractor, and I am building a office or a house or whatever it is. I cannot deliver possession of that house to my contractee client until I have obtained an OC, as my lord knows, or a certificate that it is fit for usage by occupation certificate or whatever else. And if after issuance of that occupation certificate the whole money comes to me, then it is not a service. Because law says, this is what they say, that at that stage is like a nimble property. I will not treat it as a service, because factually this is what is happening. You built it, you constructed it, it has come into existence in nimble property, you got an OC, then you're getting the whole money thereafter. But had it been a case like a flat buy agreement, on signing I pay 10%, then the situation is different. So now assuming, my learned friend were to turn back and say, yes, you may not have transferred property in goods, but you are still a service because you've done a construction of a civil structure, the exception becomes relevant. Because in my case, the annuity which I receive is after completion certificate.
Yes.
And that is very, very relevant in this context. I wanted to show that particular provision where my payments happen. Page 261, maybe 238 may be taken first. Page 238 of my petition.
Yes.
While I had made the submission, I am now connecting the dot in response to what the state had to say. Page 238.
Yes.
Lord has that?
Yes.
Article 15.1. Commercial operation date. Four-laning shall be deemed to be complete when the completion certificate or the provisional certificate, as the case may be, is issued under the provisions of Article 14, and accordingly the commercial operation date of the project shall be the date on which such completion certificate or the provisional certificate is issued, the COD. The project highway shall enter into commercial service on COD, whereupon the concessionaire shall be entitled to receive annuity from the authority in accordance with Article 27. So my timing for receipt of annuity is only after issuance of the COD or certificate. And this COD is issued by the competent authority, which is NHI.
So your based on this entire package.
Yes.
Here it is, I'm handing it over.
Yes.
So there's no questions.
There's no question, because I also fall under this line.
No in betweens.
No in betweens.
Okay. Yes.
Because there they say, I mean, as I had mentioned on the first day, 3 years, 30 days is what it takes to construct. 17 years is operation maintenance. For the first 3 years, 3 months when the construction is happening, I don't get any payment at all. I'm financing myself. My payment annuity starts after completion of construction and issuance of the completion certificate. And if I go by that fact, the exception to rule Schedule 2(5) triggers, because the exception is, you shall not be treated as services if the entire payment comes after issuance of the completion certificate. For a minute, my lord, comes back to the entry 5 of Schedule 2.
Yes. Yes.
Yes, my lord. This says the following shall be treated as supply of service, namely construction of a complex building, civil structure or part thereof, including a complex or building intended for sale to buyer, wholly or partly, except where the entire consideration, which is annuity in my case, has been received after issuance of the completion certificate.
So it won't be supply of service.
It can't be supply of services. So if I'm not a supply of service, If I'm not a transfer of property and goods during execution of work, the only sequitur in law that it is an immutable property. That is the only sequitur law. There is no other form of property that exists. We're not talking about intangibles here. So even the jurisdiction to levy GST does not exist on them, and that is why Schedule 3 may be taken. I'm sorry, my lord had folded the book. I was hoping. Kindly see Schedule 3, the very next page. Schedule 3.
Yes.
Schedule 3 is also issued under Section 7, which defines what a supply is, which is the jurisdictional fact. Activities or transaction which shall be treated neither as supply of goods nor supply of services. Which means if it is neither supply nor services, GST cannot even apply. Entry 5. Sale of land. Entry 5. Sale of land and subject to clause B of clause 5, sale of building.
So equating this to this.
They are clearly therefore saying that I don't have jurisdiction, because under entry 49, list 2, state has jurisdiction to levy tax on building, lands and building. So if it is a sale of land or a sale of building where you do not qualify as a service, then there is no question of my authority to levy tax. So not only is it is a case that it's not a supply of goods or a supply of services, it gets covered by the exclusion, because sale of land would subsume, my lord knows this, Anand Mill's judgment of Supreme Court, anything below the land, anything above the land. So a highway is the metal on top of the land, effectively that. Highway has several buildings, structures, tunnels, etc. All of those things are all buildings, structures.
Yes.
Therefore, and the meaning of the word Anand Bill, I'll just place the judgment, I will not read it out, just tell the paragraph number 43. So that time is of essence here. Para 43 is where it starts. Until para 51, page 29.
Yes.
I will not read it out below. Until para 51, what the Supreme Court has said, in 4 learned judges have said, when we look at land based on English law, anything above the land up to the sky, anything below the land until the earth's metal crust is land. This issue was in the context of imposition of property tax on cables that were being laid under the earth.
Okay.
This principle was reiterated very recently in the 9 judges constitution bench in the Mada judgment, where the mining rights were being examined. I'll just tell the paragraph number. In fact, my lord, I was appearing in that constitution bench in the Mada judgment. Therefore, it was a privilege to have assisted the court in building the law. The same page number? Page 158 of this judgment, majority judgment. 9 judges. Page 158, para 270. 80.
Yes.
Is it 80? Yes. My lords are there, may I read para 270. It's a small paragraph, I'll just therefore read. The interpretation of the words land. Yes, Bhattacharya has it? Yes. The interpretation of the word lands has been considered by this court in several decisions. In Raja so and so, The provisions of UP Landholding Tax Act 1957 were challenged for falling beyond the legislative competence of the state legislature. It was contended that the expression lands under 1949 list 2 does not include agricultural land. Rejecting this contention, Justice Gajendra Gatkar, as the learned Chief Justice then was, speaking for the Constitution bench, held that the word lands is wide enough to include all lands, agriculture otherwise. In Anand Mills, which is the judgment I had just presented earlier, versus State of Gujarat, this court held that the word land includes not only the face of the earth, but everything under or over it, and has in its legal significance an indefinite extent upwards and downwards. The above decisions are authority for the provision that the ambit of the word lands under 1949 list 2 comprises all types of land and covers everything under or over it. So basis this, my humble submission is highway is land. When I am doing a conveyance of that land after 30 years, it's a sale of land. The state, center, nobody has jurisdiction under the GST Act. They may have under other tax law, we are not concerned with that. That's the second thing I want to place before I move further. Then, my lord, the third thing I want to also say is, yes, other day I made a mention about construction contract is different from BOT, annuity, etc. My lord, as they say, proof of the pudding lies in its eating. I'm carrying a construction contract for my lord's perusal. I'll just take 2 paragraphs to be shown to show how distinct and separate a construction contract is. Yeah. This is 5th March 2019. Ministry of Road Transport, subject standard EPC agreement for National Highway and centrally sponsored road works project to be implemented under the engineering, procurement and construction mode. Milord recalls the report said, yes, this is the third mode. This is the standard contract. I will not trouble my lord with too many things. I just want my lord to have a look at para 2.1, which is page 21. And on the side, if I may request my lord to keep page 205 of my petition. Then my lord can see the comparison very clearly. Page 21.
Page 21.
Page 21. Page 21 will be at the foot. Sorry, what is the page? Para 21. Para 2.1. Page 38.
Of this
new one. Lord has that?
Yes.
This is the scope of the project. I beseech my lord to compare this. Keep this page on the one side and page 205 of my petition on the other. The distinction will be like chalk and cheese.
Scope of the project.
Yes, both the scope of the project.
It says replication.
Except
yes,
that the word operation is missing.
Yes, so see, scope project shall mean include during concession period. Unless given the scope of the project, yes, shall mean and include. Yes, construction project highway.
So in my petition, page 205, my lord will see that there is an operation that is there.
Operation and maintenance.
Yes.
In your contract.
Yes. And here in the construction project, operation word is not there at all.
Maintenance.
Only maintenance. And this is the fundamental distinction that I have been trying to persuade this honorable court. That operation is the heart and soul of this particular project, and operation means permitting people to access the road, operate. They put the highway to use. When I say I operate a machine, I'm running the machine. When I say I'm operating the highway, I'm actually letting people use it. It's to put the asset to use. This is the most vital distinction between a construction contract that the revenue, both center and state, wants my lords to believe and agree versus what it reality is. I don't want to trouble with any other clauses, but these are all there. So that's the other thing I wanted to clarify, make good my submission on this particular aspect, my lord. Now, it now brings to the last point in this whole aspect of who am I, because that was the first issue that the state and the center had raised. If I heard my learned friends clearly on YouTube and also that on live that day, the case of the state is in a toll, the service provider is the toll concessionaire, service user is the user, people like me and my friends. So service provider is the toll company, toll concessionaire, and user are people who are applying. And he says, both of them say in unison, then in annuity, the service provider is the concessionaire, but the user of service is NHAI. That's the point that they have made. On the plank, that toll was rightly exempt because see, they are allowing them to use, access, take payment and allow. That is what the plank was. Therefore, it is nobody's case that the toll exemption was correctly given. Their trouble is that in annuity, since I get the payment from the NHAI, therefore I don't fall into that. Now, three things are very important, Lord.
Yes.
Neither the state nor the center has submitted any documentary proof, any substantive authoritative paper which shows that in a toll the service provider is the toll company and receiver is the user. Nothing is provided at all, no paper, no statute, no government document to that effect, nor does the adjudicating order even speak about it. It's a different thing that they have traveled beyond that, but I'm meeting that point. To the contrary, I may now assist the court on this particular point. I wouldn't have raised this had it not been raised by them, because otherwise I would have started it at the very beginning. The law is as follows. Because it is a public function, the right to levy is with the central government. Right to collect is being given to the concessionaire.
Yes.
Now, my lord, under Article 265, just as an analogy, no tax can be levied without authority of law. Tax levied and collected. Constitution bench has said levy means imposition authorized by law. Collection is the administrative aspect of that, physical realization of the good. So the statute says, and I'll present that, the power to levy the toll is with the central government. The toll company is being told you go and physically realize it from the user because you are at the situs. In situ, you are sitting there. Then what does the central government say? Once you have taken the money, you will keep it with you. I will audit it. I will make an audit of how many users came and how many amount. If it was his money, why would the central government audit it? And then it says, after all these checks and balances have happened, you shall be authorized to appropriate it for the services you have rendered to me in the NHI. Now, appropriation happens when it is somebody else's property. That's when appropriation happens. Misappropriate means when you should not have appropriated, it was somebody else's property. So the word appropriation means the toll company is holding the money in custody.
What is?
And he is permitted to appropriate as a consideration for the services he has rendered to NHAI. I ask myself the question, then the status is the same. In his case, money comes, source of fund is the toll which the government gives to him. In my case, source of fund is the annuity which the government gives to me. I am therefore at par. There is no question of any difference. And if they say that the toll exemption has been rightly given, then what stops them from giving me the same exemption? Why should my entry be read any different? So therefore, my lord, may I show those provisions to make good my submission? Yes, my lord, volume 11 may be taken, which I had submitted last time. Because the arguments of the state and center is based on perception. That's why I said no document was placed, no statute was placed to say that in the case of toll the user pays, whereas in my case the NHI pays. Page 2 of volume 7.
1 second.
Volume 11. This is the National Highway Act. I'll take time. Lord, page 2. This is National Highway Act.
Yes.
Now, in this, kindly come to page 6.
8A.
8A. This is the mother clause. 8A says, notwithstanding anything contained in this act, the central government may enter into an agreement with any person in relation to development. So this is what authorizes the concession. Kindly see clause 2. Notwithstanding anything contained in section 7, the person referred to in subsection 1 is entitled to collect and retain fees. Collect and retain fees. Whereas the levy is in section 7, just the previous page. Fees for services of benefit rendered on national highways. The central government may, by notification in the official gazette, levy fees at such rates as may be laid down by rules, and in this behalf for services of benefits rendered in relation to the use of ferries, permanent, etc., etc., etc. So for the services that the central government renders to the users, the levies by the central government, power has been given to the concessionaire to collect and retain. So the levy is not by by the concessionaire. This is what comes out clearly from this. Then my lord comes to page 62. Page 62. This is the rule. Lord has that?
Yes, yes.
In exercise of powers conferred by section 9 of the National Highways Act, these rules have been enacted just to show the source of power. Now, in this, kindly come to rule 3. Lord sees that?
Yes.
Rule 3. Levy of fees, which is at page 63.
Yes.
The central government may by notification levy fee for use of any section of national highway, permanent bridge, bypass and tunnel forming part of a national highway as the case may be in accordance with the provisions of these rules. So the levy is it's been reiterated. Now clause 3 may be seen. In case of private investment projects, and that word is defined in clause M. For a minute, may I read the definition of private investment project? Private investment project means a project relating to section of national highway, permanent bridge, bypass or tunnel as the case may be, for which an agreement is entered into with a concessionaire. So our case, it doesn't say BOT or BOT annuity, nothing. So both the cases. In case of private investment project, the collection of fee levied under sub-rule 1. So the levy is under sub-rule 1, which is by the central government. And the administrative or the physical act of collection is what Rule 3 talks about. The collection, in case of private investment project, the levy of fees levied under sub-rule 1 shall be made in accordance with the terms of agreement entered into by the concessionaire. That is why the enabling clause is there in the concession agreement that we shall collect. Now it doesn't stop there. Now my lord comes to Rule 7. Rule 7, Rule 6. So we read out Rule 3, which talks about levies by central government. Levy collection can be by them. Rule 6 says, which is page 68, the fee levied under these rules shall be collected by the central government or the executing authority or the concessionaire as the case may be. Clearly distinguishing between levy and collection. And kindly come to Rule 7. This is the most important. Remittance is an appropriation of fee. In case of public funded projects, in case of public funded projects, the fee collected under the provisions of these rules by every executing authority shall be remitted to the central government, provided that the central government may by notification allow any or all executing authorities to appropriate the whole or any part of the fee for such purposes and subject to such conditions as may be specified. Provided that In the case of private investment project, which is us,
Yes.
the fee collected under the provisions of these rules
Shall be.
shall be appropriated by the concessionaire in accordance with the provisions of and for the performance of its obligations under the agreement entered into by such concessionaire. Clearly says the appropriation is for the performance of the concessionaire's obligations under the agreement. So it is a misnomer, it is a wrong assumption or perception that in a toll he is collecting for he giving access. This rule makes it clear that he has rendered services to the government, he needs to be paid. Government says, you are in possession of this toll, I am going to permit you to appropriate it towards the services that you have rendered under the concession agreement. It's the same thing what I do. Instead of from the fund of toll, it comes as an annuity. No difference whatsoever. Then there is another rule, my lord, page 77. The National Highways collection of fees by any person for the use of section of National Highways, permanent bridge, temporary bridge, National Highways Rule 1997. My lord sees that? Kindly see
Yes.
Rule 3.
Yes.
The central government may enter into an agreement with any person in relation to development and maintenance of the whole or any part of the national highway, permanent bridge, temporary bridge or national highways as it may decide, whereby the person may be permitted to invest his own funds or the development maintenance of the section of national highway, permanent bridge, etc., and to collect and retain the fees as agreed rates from the different categories. And then rule 6. Would seal the thing that they are not the owners of the money. Rule 6. It shall be the responsibility of the person referred to sub-rule 1 of Rule 3 to strictly ensure that all fees leviable are levied, fully collected and correctly maintained. The person shall submit certified and audited copies of the statements of fee collection at specified intervals as required under notification for collection under subsection Rule 2(3). The auditor shall be appointed by the government. The central government shall have the right to check the fee collection at any or all times through their designated officers. If the monies were theirs for the services that they have rendered, why should the central government fetter with the accounts? That's my question, my lord. So therefore, my humble submission on this point is that the perception that the tolling fellow does a service to user and I don't is wholly without any basis. To the contra, the statute makes it very clear that they do exactly what I do. The modus of getting compensated is maybe different, but ultimately both of us render something to the National Highway Authority, the central government. Neither of us are doing anything to the users. And I ask myself the question, if 23 and 23A were to be read, the language is identical, services of access of road, one says annuity, other says toll. Then, my lord, and they have no objection to toll being exempted so far, they have not said anything contrary. Then any interpretation that takes a view otherwise, for me, would be invidious violation of 14. And if there, and this is in the context of Dilip Kumar's judgment that my learned senior mentioned, exemption notification has to be interpreted in a manner that benefit goes to them. It is equally true when you interpret, if an interpretation leads to violation of constitutional provisions, then you have to lean towards the one that is valid. Kedarnath, my lord, that law of sedition, constitution bench judgment.
Yes.
So therefore, I say that as my lord prods into this interpretation of the two entries, keeping all of these things in mind, this perspective may have to be kept in mind. Now, I'll now come to the other points on Kedarnath, on the aspect of Dilip Kumar. The learned senior has made a reference to that, para 53, 55 and 66 of Dilip Kumar, which Pelot will find in his compilation. His compilation, I think he calls it flag D. What is it? Sir, would you remember what flag was it?
A.
Flag A.
I'll just check it, please.
Yeah.
Like A.
Yes. Is the first judgment.
1 second.
In the, Mr. Bozika's compilation. Paragraph.
1 second. Yeah. Yes.
Para 53.
It's a deluge.
Yeah, it is a deluge. I understand, my lord. I'm so sorry for this.
No, you have to do your job. So,
Well, I had to get into these because of the submission that came from them. Because the adjudication order does not make a reference to any of these. So therefore, I had to deal with
exactly, because once it brought up the matter of composite and mix, so that's
Right.
the thing.
Correct.
Yes. And so you're going to at pains to show that it's not a...
that. Exactly.
not a
I'm so
obstruction.
compliant.
Yes.
So Dilip Kumar, my learned senior, had made a reference to para 53, 55 and
Flag.
Flag A.
First one, flag A.
Yes, flag A,
53, 54, 55 and 66.
66. I'll read 66, which is the essence.
Yes.
Exemption notification should be interpreted strictly. The burden of proving applicability would be on the SSE to show that the case concerns within the parameters of the exemption clause or exemption notification. When there is ambiguity in exemption notification which is subject to strict interpretation, the benefit of such ambiguity cannot be claimed by the subject SSE and it shall be interpreted in favor of the revenue. Very valid point. But the central government has not, or the respondent central government has not, Union of India has not submitted what happened to this judgment thereafter. The clock did not stop here. A subsequent decision came to be rendered by the Supreme Court in the case of Mother Superior. Melot takes volume 9. Volume 9 is before the bench? Yes. By a division bench.
One second. How much long will you take with the Ghosh?
I'll take some time, Melot. Melot allows me some time because these are things that I have to deal with and this is a pure question of law. I understand, but what do I do? These are points that are being raised.
He has a valid point because you see, in the beginning it was a totally different aspect. Now after Mr. Sinkon brought up that, composite and big, that is the thing. That if he's engaged in construction, that means whatever falls, even ancillary to or whatever, it's all part of the contract. And
Well,
so
the main issue or what we have raised, my lord, the alternative remedy.
I will do that. Sir, I'll do that.
So, my lord, I would urge your lordship to first decide whether your lordship will go into all this detailed discussion or your lordship will only examine the alternative remedy part first, my lord.
they should have put that in the beginning.
Well, I've said that. That was my.
Now let me conclude.
That was my first reply.
Yes.
Lord, page number 139. Lord, has that?
Yes.
Government of Kerala versus Mother Superior Adoration Convent. Kindly have page 159, para 25. May I read?
Yes.
A recent 5-judge bench judgment was cited by Sri So-and-so in Commissioner of Customs by Dilip Kumar. The 5-judge bench was set up as a 3-judge bench in Sun Export. In Sun Export was doubted as the said judgment ruled that any ambiguity in a tax exemption provision must be interpreted so as to favor the SSE, claiming the benefit of such exemption. This court, after dealing with a number of judgments relating to the exemption provisions in tax statute, ultimately concluded as follows. Para 66, Milord, I have read out from that. I did not trouble Milord with that. Para 26. It may be noticed that the 5-judge bench judgment did not refer to the line of authority which made a distinction between exemption provisions generally and exemption provisions which have a beneficial purpose. We cannot agree with Sri So-and-so's contention that sub salientio the line of judgments qua beneficial exemption has been done away with by this 5-judge bench. It is well settled that a decision is only an authority for what it decides and not what may logically follow from it. Queen versus Latham and Sudhanshu Shiksham Mishra. So therefore, and then the para 26, this is because this being the case, it is obvious that the beneficial purpose of exemption contained in section so-and-so of that act must be given full effect to in the line of authorities being applicable to the facts and circumstances of this case. Now, therefore, the question is the moment you get into that, this is the purposive construction that will have to be done. And my lord, I take pains to go back to the purpose. Purpose was to keep toll and annuity at par. That was the purpose. The GST Council's meeting, which my lord will find at page 370 of my petition,
Yes, yes.
and the agenda and the conclusion minutes of the meeting, which is at page 377, was the purpose. And we apply the purposive construction as their Supreme Court has said, subsequent decision. There can be no manner of doubt, it is my respectful submission, that they have to be read at par in the manner that was contemplated. So Dilip Kumar also does not apply in that sense. Learned Senior Counsel also made a mention of the Telangana High Court judgment. Again, all these are on merits. That was flag what? Flag C. What is that flag, sir? Telangana High Court. GMR. B. Flag B.
Second judgment.
Yes. Flag B.
Para 3.
Yes, my lord. Now, once again, they have failed to place before my lord what happened to this judgment thereafter. It's a selective placing of
sequel to the.
Yes, it's a pattern that the subsequent decisions of the Superior Court are not being submitted. This judgment, 226 discretion was not applied by the court, saying that you are at a show cause stage. Now, what happens is 226 as a barrier. If you say I will not exercise discretion, then you are not supposed to comment on merits of the case. You can't get into merits. You'll have to say why your discretion you don't want to take in, because alternate remedy is the efficacious remedy. That is where the matter ends. With greatest respect, the learned judges of the Telangana High Court went about discussing merits also, supporting the view that the revenue had taken, and then said that anyway these are things to be decided by the adjudicating authority. When the matter SLP was filed before the Supreme Court said yes, alternate remedy, but all these comments on merits
will go.
Ignore. So I will not read all of this decision that he has rendered. I will only show the Supreme Court order, which my lord is at page 137 of my volume 9. So any judicial utterance that may have been found in the Telangana High Court decision will have to be ignored. That is my respectful submission. So therefore the submission that the issue is already decided is not correct. My lord has page 137.
Yes.
GMR Pochenpalli Expressways versus Additional Director General of GST, 27 January 25 order.
Yes.
Lord sees that. Kindly turn to the next page, second paragraph.
In view of the above.
In view of the above, we are not inclined to entertain the present special petition. However, we make it clear that the observations made in the impugned judgment on merits will not be treated as final or binding findings. All issues and contentions, including those pertaining to the circular, may be raised during the course of adjudication proceedings pursuant to the impugned show cause orders. So reference could not have been placed on this particular decision. That is my respectful submission, to say the issue is already decided. That was the submission of the learned DSG. Now I come to the composite supply aspect. My submissions are twofold, my lord.
How much longer will it take?
I'll take another hour and a half at max, because I have to deal with
Yes.
alternate remedy also.
Alternate remedy, yes. That will deal all the aspects also. Yes.
No, that will be 10 minutes I can complete. I'll introduce the composite supply.
Otherwise, if we on a different limb now, we will.
No difficulty, my lord. Yes, my lord. Then my lord may keep it on 21st. 21st.
Yes, September.
21st. This is September. Sorry. This is
Yes, depends on the side.
21st is Thursday.
Yes. Yes, post a matter for further hearing on 21/8. Yes.
Very well. And my lord, that on that day the state should come with their response to the.
We will. Huh? It'll be there, 22.
The state should come with the reply to that contemptuous act that they have done.
That is on the miss case.
Yes.
Yes. Huh?
I'm so blind.
Any mention?
Please, Your Lordship. Your Lordship, I beg to mention item 25.
25.
Your Lordship, conducting counsel Mr. N.D. Shulai has some personal difficulty today.
No objections, Your Lordship.
What is this? Granville Hali Hasha?
Yes, Your Lordship.
Yes, 2 weeks, yes. Yes.
Your Lordship. Oh, sorry.
Okay.
Yes, you have some objection?
No,
25.
I want to beg more time for serial number 27.
Why? What 27?
27. Embossed, Your Lordship.
Who's for the petitioner? MS Ibla, yes.
Please, Your Lordship.
You no objection?
2 weeks, Your Lordship.
Okay, yes. Yes.
Your Lordship, I have similar prayer for item 13, 14 and 15.
13?
13, 14 and 15.
13, 14, 15.
Yes, Your Lordship. They're connected matters, Your Lordship.
Your objection? Yes?
No objection, Lordship.
After 1 week?
After 2 weeks, Your Lordship.
Why? It's 22 matter. Okay, 2 weeks, yes.
Obliged, Your Lordship.
Yes.
May it please, Your Lordship. Your Lordship, I beg to mention item number 17, Your Lordship. I pray for 2 weeks' time, Your Lordship.
I have no objection, Lordship, for District Council.
Yes, 2 weeks. Okay.
Similar prayer for item number 19 also, Your Lordship.
No objection, Lordship.
Yes.
Your Lordship, item number 26 also, Your Lordship.
Yeah, also same, Lordship. District Council, no objection.
This is also very accommodating, yes.
I also beg to make a mention of item number 22, Your Lordship.
What is this?
In item number 22, Your Lordship, we have just received a copy of the affidavit, additional affidavit filed by the respondent. Let it come
correct?
for hearing,
Lordship, we had already filed on the last day, Lordship. On the last day, there is sought for rejoinder, filing for rejoinder.
Okay, 2 weeks, yes, for your
We
joint.
won't be filing, Your Lordship.
You won't be filing?
No, Your Lordship.
Yes, after 2 weeks on the prayer of some sort. Yes.
Highly obliged. Your
And
Lordship.
mark this.
Much obliged, Lordship.
Please, Lordship. Lordship, I beg to mention item 20 and 21 on behalf of the District Council.
Behalf of whom?
District Council, Lordship.
Where's the petitioner? PT Sangma.
Lordship.
Yeah, objection.
No objection. Praying for 2 weeks'
Hey,
time.
he also has objection. Yes.
And 21 also, Lordship.
21 was a yeah objection?
No objection.
Yes.
I'm obliged, Lordship.
Yes.
Please, Your Lordship. Your Lordship, I beg to mention item number 23.
Not only adjourned 23, the whole list, Independence Day list is gone. Yes.
No objection, Lordship.
Yes.
Highly obliged.
Much obliged, Lordship.
24, 18, and 16. I'm not sure. Okay. So, follow the motion list.
Supplementary list item number 1.
Yes. Kangamban.
Your Lordship, this matter is related with CMJ University, Lordship.
When you bench road me. Yes. Yeah.
Item number 2.
May I please, Your
Yes,
Lordship?
MS Rahman. What do you want?
Lordship, this matter is regarding the Village Employment Council, Your Lordship.
Another one.
Your Lordship,
Signing elections or wanting to hold elections?
want to hold election.
Wanting to hold elections.
Yes, Your Lordship.
Yes, you take notice.
Yes, Your Lordship, on behalf of all the respondents.
Any interim prayer?
Lordship, yes, a small prayer, Your Lordship. During the pendency of this matter, Your Lordship, Lordship, my humble prayer is that no BC functionary should be conducted on selection process, already hand-raising process, Your Lordship.
Let's see a prayer. This is Nolbari and Bajbari, Batabari.
Batavari, CNRD block, Your Lordship.
No, what is your prayer? Why you say should not? It's not here, pendency.
Is to direct the respondent number 5 to conduct free and fair impartial election of Nalbadi VC under Bajbadi CRT block within a reasonable period of time.
Your Lordship.
Only this much prayer, Your Lordship. No interim.
That's why if they,
Well, you should make interim prayer at least in the main
There is no
petition.
prayer, Your Lordship.
Lordship, only my small prayer is that no election should be, no selection should be conducted during the pendency of the matter.
Should be
Otherwise,
election.
my selection, Your Lordship, selection or any hand raising process should not be conducted during the pendency of this matter, Your
No,
Lordship.
what you're submitting is that election should be as by secret ballot.
Yes, Your Lordship. In free and fair and impartial.
Yes,
But Your Lordship, I
Rahman
have
issue notice. So MS Bhattacharjee is present. Except notice we have all the respondents. No further notices called for. The writ petitioner. Who's the writ petitioner? He is a
It's
job
a
card
job
holder.
card holder, Your Lordship.
Who's the job card holder belonging to
Nolbari.
Nolbari NOLBRBEC under Batabari, Sinadi Block, West Garo Hills, is before this court with a prayer for directions to respondent number 5 to conduct free, fair and impartial elections of the Nolbari VEC within a reasonable period of time as fixed by this court. Stop. MS Emanat submits. When did the last VEC?
It was conducted on 3rd of March 2024. It was expired on 3rd of March 2024, Your Lordship. It's been 16
expired
months.
on?
3rd of March 2024. 3/3/2024.
Now where is that? Where
It is paragraph 3.
Para 7.
7, Your Lordship.
Page 6, Your Lordship.
6 and 7.
6 and 7.
MS
7 is
Emanat
the
submits that the Nolbari VEC, Nolbari VEC's term has since expired on 3/3/2024. Until date, no election has been conducted by the respondent authorities, and the said village is running without the VEC for more than 16 months, which has led to 16 months stop. They have done the verification.
Your Lordship, we have filed representation, but no forthcoming has.
Your Lordship, I may be allowed to 2 weeks time to get instruction, Your Lordship,
Yes.
before allowing.
He also praised that the elections, if any, to be conducted should be free and fair and not by selection
Selection, Your
or
Lordship.
by raising of hand stop. MS Bhattacharjee, praise Fellow, how much time? 2 weeks time to obtain instructions and to file affidavit. Yes, list accordingly on so and so.
Much obliged, Your Lordship.
You've recorded a submission. We didn't make a prayer of recorded submission, so at least that you made a, that it should be by, not by election, not by selection.
Your Lordship.
Yes.
Item number 3.
This is the Istiaq Alam. We'll have it at the thing, we'll have it second half.
My Lord, may I mention 3 cases are there. The third petition, my Lord, we have committed a serious mistake. With regard to respondent number 15, the name was wrongly mentioned in the cause title, my Lord, in the third petition, my Lord.
And item number?
Item number, my Lord. That is WPC number, my Lord, 445.
445, yeah. What
It is a
happened?
connected matter, my Lord.
Yes.
Here, my Lord, we have committed mistake. The private respondent number 15 name was wrongly mentioned. Instead of mentioning, my Lord, Mr. Mopiqul Islam, my Lord, it was mentioned as Mopiqul Hussein, and service has been effected in the name of that person. In fact, we have filed a service affidavit also. It is returned. If Lordship give me a week's time, allow me to correct the mistakes and issue a fresh notice regarding that person only, madam.
Is it very vital?
It's very vital, madam, because it's wrong. It has gone to the wrong person, madam.
What about the other, who are the other people appearing, other lawyers appearing in this matter? This is Mr. Siddiqui is there. In which matter? In number 4. 1 week won't be enough to effect notice, but it's so vital matter, can it be carried forward in his absence?
My Lord, in his absence, he may say that
he'll come.
He may say
Then
he
you
never
put an
received.
application, Mr. for striking out for correcting the name.
But only the title of that person. If
So you
Lordship
have to
correct.
put an application. It is a code of record. They have to go and record.
But within a week, next week,
Your Lordship, otherwise the AG is ready, Your Lordship.
No, it is ready, but then if that is the situation,
Yes, Your
then
Lordship.
the other fellow will file the appeal
Just file
saying
the
that I was.
application, Your Lordship.
Yes, Mr. So before these matters are being taken up, has submitted that, has put him to bring an application for correction of the cause title and the name of respondent number 15 who has been incorrectly shown. Stop. If further submitted as the vital respondent, the application may be allowed. Yes, on hearing submissions. What is that? Huh? On hearing submissions also, prayer is allowed for application, yes. Just after 1 week.
After
Yes. Or connected matters means that is
three cases are connected.
4, 5. What is that? That is number 4. 3, 4, 5,
up to 6.
3, 4, 5, 6. Yes. Yes, we'll have it after 1 week. Yes. After 1 week. Yes. Yes, Mr. Hussein. I alum is present on behalf of respondent number 14.
6.
6, sorry.
6.
NCT. Yes.
Item number 7.
We'll take it at 2 o'clock. Yes. You have prayer?
No, madam.
You ready with the matter?
Yes.
Yes.
Daily list, item number 1.
Yeah, no. No, we'll take up all the rest of the matters at 2 o'clock. Yes. Around.
supplementary list, item 7.
Yes.
May it please, my lord. My lord, on last occasion, my lord, the issue of maintainability has been raised and questions had fallen from your lordship whether this issue or whether the case of the petitioner is a civil dispute. My lord, I am here today will be convincing your lordship that the instant case of the petitioner is actually the petitioner approaching this court for enforcement of his fundamental right, which have been violated by the actions of the respondents.
Yes. What respondents?
My lord, by the respondent number 1 and number 3, my lord.
1 and 2 is?
1 is the Sardar, 2 is the executive committee of the Darbar, my lord.
Yes.
Yes, my lord. My lord, the first issue that I'm going to take your lordship with regards to is the jurisdiction of this court, my lord.
Yes.
The petitioner has approached this honorable court under Article 226 of the Constitution, which is the powers of the High Court to issue writs.
Okay, why?
My lord, for the simple bare fact is that the respondent 1 and 3, my lord, they are both deriving their powers from the Constitution through the acts passed by the district council, my lord. So by the fact that they are drawing their powers from the Constitution, they are also bound by the principles and the law which has been enshrined in the Constitution itself.
No, one thing, Mr. Bissell, you have to show us which way is fundamental right based.
Yes, my lord.
That they will come to that.
Yes, my
Can
lord.
be any authority.
Yes, my lord. I'll come straight to that.
Person or any entity. It doesn't matter. But if you show that their fund has been violated,
yes, my lord.
That's why the alternate remedies will not be efficacious. That's why you've come before this court.
Yes, my lord. My lord, I'll take your lordship straight away to Annexure 19, my lord, which is in the main petition. Apologies, my lord, I'll take the annexure. Yes, my lord. Annexure 19, which is at page 76 of the writ petition, my lord. My lord, this is the copy that was served to us, and I'll take your lordship to the translated type copy on the next page.
Yes.
My lord, kindly note, my lord, the date 8/10/2024.
Yes.
To the petitioner. May I read, my lord?
Yes.
That the executive committee of the Sardar Darbar Nongsteng Pallun have thought of a decision on 7/10/2024. We have decided to inform you, and the decision has been enclosed for your information. Just this much, I believe you understand. My lord, only one moment I take a pause. Kindly note that there's no elaboration on this order that they've passed.
Where's
There's no
the order
reasoning.
passed?
Now,
the
next page, my lord, the next page is them annexing a letter from the respondent number 3. They have sent this letter on October of 2024, and they annex a letter from September of 2024 sent by the respondent number 3. Now the type copy of this letter, my lord, the translated type copy is at page 82. Lord, we'll have page.
What is the summary?
My lord, I'll come to that, my lord. I'll just take my lord to that, my lord. Kindly have page 82, my lord.
I read the Kazi version. Yeah.
So page 82, this is a letter sent by the respondent number 3. Kindly note, my lord, to the Sardar of Sora Simship. My lord, if I may read the contents, my lord. With regards to the subject and letter mentioned above, I, the same, and the Darbar have this to say below. That this office, in its decision made on 29/10/2016, has revoked the property, land given by so-and-so at the time to a person who is an outsider. A Xerox copy of this decision dated 29/10/2016 is enclosed to you. Now, my lord, kindly note, my lord, the letter that they sent to us was on the 4th of October 2024, annexing a letter in backdate of September 24, further annexing a decision made in 2016.
Yes.
Now, my lord, if my lord would be gracious to allow us to admit this appeal, I'll take your lordship through the entirety of this decision. However, I'll only take your lordship only to the last part, which is at page 86, the decision, my lord.
Yes.
decision. After the same and Dorbar conducted thorough examination of all relevant documents received by the office and those issued by this office, it is decided and revoked the the giving of land by the Sardar to the individual who is an outsider. And
You are the outsider?
Yes, my lord. And the Sardar has violated condition number 3 of the Sanan. The Sardar Nuxteng is warned, and from now onward he is not to repeat the violation of any condition of the Sanan.
What happened after this? It's 2016.
Exactly, my lord. This was passed in 2016.
Never communicated to you?
Never given notice, no opportunity of hearing, my lord. Audi alteram partem gives us the right that we will be heard. They have never issued any document, any letter to us saying that this decision, before reaching this decision itself, my lord, there was a proceeding conducted where they receive a complaint, conducted
land
inquiry.
Was given to you outright or on lease?
My lord, it's not lease. My lord, this is why a detailed hearing will be required, my lord, to read the contract in detail, my lord, because I also want to place a judgment on record, my lord. But the only reason is that if we go into the merits of the case, my lord, the case should be admitted. Today I'm only here for the issue of maintainability.
Yes, you have any objection to admission? We'll hear it.
My lord,
the delay is maintainability.
Yes, my lord.
Modify,
Yes, my lord. My lord. What the question here is, my lord, is when a thief is caught, he comes to the run for a protection, my lord. Simple as that, my lord. We have been asking him, how did you manage to get this land? Because
you are respondent number 3.
I am respondent number 1 and 2, my lord.
Okay. Yes. And you're the Sardar who gave the land to him?
No, my lord. I am not the Sardar who gave the land, my lord. We are the incumbent, the last incumbent, my lord. He is the one who gave the land to him.
My lord, I want to interject on this junction only, my lord. The previous incumbent, he was present in office. This decision I just read just now, my lord. He was only warned. There was no action taken against him. Second issue is, my lord, he is not represented in this court today, and he is also deceased, my lord. They are blaming all these issues on a deceased individual, and they have assumed the office of the Sardar, and today they are neglecting their responsibilities which have been made by the previous Darbar, my lord. And implementing an order after a passage of 8 years, my lord, is highly illegal, my lord.
My lord,
yes, let's see your point. What do you have to say?
My lord,
on maintainability only.
Yes, my lord. Now, my lord,
the matter is fixed today for hearing on that.
Yes,
If you want, we can hear it together. Let the question maintainability be open.
We can do that, my lord. We can do it because as it is, if I'm going to object.
That we see here is that if by this order, whatever it is, it was passed in 16. Then how is it communicated to him in 2024?
2016, my lord, 2016, my lord, there are some suppressions of the facts, my lord. 2016, he was very much aware. He was very much aware. There was a question raised, how did you get? Now that follows, my lord, and he went on investing, and finally now the new Dorbar has come.
Intimate to us.
But yes. So when the new Dorbar has come, we have asked him, please bring on records, please come to the office and show us that how did you get this property, because the Sanat itself, when the scene.
Don't go there, Sanat.
Yes.
The thing, we just come to the chronological. There is now the thing is that now petitioner rather says that only in 2024.
Yes.
He was given the 3-line message from the Darbar.
Yes.
Saying that it's over. This is because of decision taken, the summary, whatever was given there.
Yes.
Right. I mean that findings.
Yes.
So then how did outsider get land? Finish.
Yes.
That's all.
Yes.
Now he says if the decision was taken 2016, why was he not at least given notice before that?
Yes.
My lord, they did not implement the order as well.
My lord, this statement, my lord, it's been seriously disputed, my lord. This is seriously disputed, my lord. Whether he received someone, whether he knew or not, how did he manage to get, my lord? These are serious questions of defense.
Now, okay, the other important question: who's in possession of the land now?
My lord, the lock and key is still with me. They have not approached us after they issued this order in 2024. They have just kept quiet, my lord. We've sent representation. They have not responded once also.
Yes, you are going for this EM.
Yes, Your Lordship. As a matter of fact, Your Lordship, if I may take you to the decision which was issued in 2016, which the petitioners agreed by. If we read the Khasi version, Your Lordship, the first 2 lines it says that which means that the allotment of land.
The grant, okay, whatever allotment is. Fine, but then was he? See, once he's been given, rightly or wrongly, by the Sardar, who is the head or whatever at the point of time the village, and who controls the village land. Rightly or wrongly, been given a piece of land. He's acquired some vested right. Might be wrong, might be in adverse possession, might be in anything, but acquired some vested right. Now, whether when you cancel his right or his lease or whatever the permission given, was he heard?
Lordship,
that's only fundamental question.
Take your Lordship chronologically to the chain of events.
Then we will. We will see the takedown. Heard Mr. Missil for the petitioner. The respondent number
3 issued that order, my lord.
No, the respondent's number 1 by whom?
One is me, my lord.
One is number 2.
It's Secretary, my lord.
Mr. P. Y. Ubin is present on behalf of 1 and 2, and Mr. LCM on behalf of spot number 3. Stop. It is seen that this matter was fixed today to decide for admission on the question of maintainability, in as much as it appears to be connected regarding a dispute over a land which has been allegedly leased out by the predecessor interest of the respondent number 1 to the petitioner. Stop. The next one, Mr. Missil, the counsel petitioner, has further submitted that what the petitioner is what the petitioner agreed with is the manner in which the grant of land has been cancelled without he being heard. In as much as you've invested in the land,
yes, my lord.
Just now?
Yes, my lord.
Yes, they have invested.
Yes, my lord. It's there in paragraph 14 of the petition, my lord.
And as such has acquired valuable rights. In this view of the matter, the writ petition will stand admitted for further consideration. However, the question of maintainability will be left open.
My lord, I humbly pray for stay as well, my lord. Because of this stay of their orders, my lord. The operation of these orders, my lord.
Because now are you there? It's on a lock and key.
We're making losses on a day-to-day basis, my lord.
Well,
as long as we keep locked, my lord,
after we're going to exchange.
Yes, my lord. Yes, my lord.
Exchange, my lord.
They submitted a previous complete list matter of expedition.
If you're hearing, my lord. Yes.
Yes.
Obliged.
Kindly, my lord, stay, my lord.
Those couldn't stay now. This order was passed in last
2016.
year.
Yes, my lord.
2024.
My lord, they didn't take action since 2022, my lord.
Whatever it is, should have come immediately.
Yes.
My lord,
when did you receive the order? The 24.
24 of
23. We have asked him to come.
When did you receive it?
2024, my lord, we received it. In October of 2024, my lord.
Daily list.
Interim stay is when irreparable
that's happening,
loss immediately.
My lord, that's happening, my lord. I will be allowed to bring certain documents on record during the condition.
That as on today, status quo shall be maintained.
Status quo, my lord.
That's the condition as it is, my lord.
Yes.
Obliged, my lord. Deeply obliged.
Please, Your Lordship.
Yes.
We're supposed to file our affidavit, Lordship. We've sent it for signature. I'm praying for another 1 week's
2 weeks.
time.
I'll wait for a 2 week allowed response. Yes.
Item number 2.
My lord, for respondent number 7, I'm seeking some more time for filing the affidavit in opposition, my lord.
Why?
There is some difficulties, my lord.
What's the difficulty? How many times you've taken?
Only once, and this time is twice.
Your Lordship, I have filed my rejoinder.
MSSR Marak pays funds allowed.
After 2 weeks, my lord.
2 weeks further time to file affidavit of 7. So MSGC Marbo, next paragraph, submits rejoinder since been filed to the affidavits filed by response 1 to 6.
Item number 3.
Please, Lordship, we have taken a fresh step to issue a notice to private respondent number 5, 6, 8 and 9. We have taken a step on 25/6/2025. Still we are
filed affidavit that he has been served. They've been served.
We have served, but we have still awaiting for this one. We have
Mr. P. prays for the Lord for a 2 weeks time to obtain status of service.
Yes.
Upon the respondents 5, 6, 8, 9.
Your Lordship.
Is thereafter.
Item number 4.
Much less, Lordship.
Same matter.
Yes, another matter. Another matter. This is a service matter, my lord. This is a service. The first one is
No,
the
have you
POSH.
filed your rejoinder?
Yes.
So this will be linked to other matter or no?
Pardon, my lord?
Will it be linked to the earlier matter?
Yes, your lordship, but it's not connected. It's a different cause of action.
Then parties submit a pleading to complete this matter for hearing after 2 weeks. This is a service matter.
Yes, ma'am.
5.
Yes. Separate file.
No, lordship.
Last opportunity gone.
Yes, my lord.
Your lordship. Your lordship,
It was the last opportunity, my lord.
we've received some through telephonic instructions. It appears that the work has not been completed, lordship. And also instructions supposed to come from Zakhama, Nagaland, lordship. That's why it's taking time.
So Huma, you put an application then for recall of this order.
My lord, I already executed the work on 26/03/2025, my lord.
What work did you do?
26/03.
What work is this?
This work only, your.
No, what work?
This contract work, my lord.
What contract work? For what?
For the road and all.
For the road and all?
Yes, my lord.
Okay.
And I have sent the notice dated 24/05/2025, my lord. After that, no reply.
Though last opportunity was granted on 4/8/2025 for the respondents to file the affidavit, MS Emerchang today has expressed her helplessness. MS Emerchang, Vice Dr. Muzika, has expressed helplessness and submits that they have been unable to file the affidavit as the work is situated in Zakhama in Nagaland. Stop. However, has apprised the court that telephone instructions have been received, and to the effect that the writ petitioner has not completed the.
I already executed, my lord. My paper is there, my lord.
You got a completion certificate also?
No, they didn't issue, my lord.
Yes. Has not executed executed contract fully. Stop. Next paragraph. The same is disputed by Mr. Mia. Yeah, Mr.
H. Mia.
H. Mia, who submits that. Stop. In his view, the matter, considering the nature and circumstances of the case, though last opportunity was granted on 8/4/2025. Yes, what after last opportunity? What's it called? Next after last is the another word. Last, final opportunity, last opportunity.
Final lordship.
Then we have to give a judicial order. What do you mean by last opportunity? What opportunity will you give then? You say the what word? The last one is granted by order 8/4/2025.
4/8/2025.
In the interest of justice, because it's necessary, the affidavit is necessary.
Yes.
Interest of justice as an affidavit is absolutely necessary from the part of the respondents. They are granted
3 weeks time, not sure.
3 weeks. I will not say final time to file affidavit, failing which costs will have to be paid. Yes.
Item number 6.
It has no meaning. Last, final.
Lordship, in this case, pleadings are complete. So I have, morning hours, I have discussed with Mr. Themis Dingdo. He said, let it be fixed for hearing. 6 and 7, the similar matter, Lordship.
Yes, sir. But the pleadings are complete. This is a matter for hearing. Yes.
7 also same, Lordship.
6 and 7.
Item number 8.
Your matter same.
Yes, we have already completed pleadings.
Yes, 6, 7, 8. Have they appointed other people?
No, as far as we know.
departmentally.
Not as far as we know.
You get instruction before the next hearing. But
Yes.
that will be very important.
Yes, we have stated in our affidavit in the.
They appointed someone else.
They have not appointed anyone, though they said that they'll be taking steps to call for fresh tender, but they have not yet called for fresh tender also.
9.
You received the NET certificate?
This morning we received one email whereby they have stated that they have issued the certificate, but till now we have not.
Issued when?
This email was just. It's just written that certificate has been issued. And this was received today at 11:44. So, Lordship, 1 week may be given.
Where's the reply? This is the reply. This is your email. There's a complaint regarding non-issuance of UGC net certificate.
The reply is on top, Lordship. Dear candidate, the certificate.
Dear candidate, the certificate has been issued. Kindly check. Okay.
That's the only.
Mr. Pariat, accounts KK Pariat. JK Pariat, a learned counsel picture submits that an email has been received today, wherein the respondents have communicated that certificate has been issued. However, submits that the same yet to be received. Stop. Next according to the matter after 1 week for further orders. Yes.
Hello, Pledge.
Item number 10.
Lordship, I beg to enter evidence on behalf of Miscellaneous number 6, the impeded party.
The impeded party? Was that Hito?
Alert.
Who are they?
Lordship, they were an NGO. They were the foreign.
What did they do?
Lordship, what had happened is they had lodged an FIR as well as certain notices and all.
But on the basis of NGO, can a lease be truncated?
Lordship, that I leave it for the district council. But what had happened?
You file affidavit.
Lordship, I'll file an affidavit.
And then one thing also, you file your articles of association or memorandum.
Absolutely, Lordship.
And then we will have some questions also.
All the FIR and the.
That's because we can't have we can't have NGOs trampling all over the place and constitutional authority went so backwards to.
We had only lodged an FIR to the police saying that they have been collecting some certain amounts without issuing receipts. That was all the.
Ms. S. Deb has an appearance today on behalf of the respondent number, the impeded new report for number 6. Stop. The praise funds allowed.
I may be allowed to take instructions. File an affidavit.
Be allowed 2 weeks time to take instructions and file affidavit. What about talking about Zika? When you filing affidavit?
Another 2 weeks time.
Similar times allowed to respondents 1 to 5 to put in the affidavit. This thereafter. Interim orders.
It's until further orders, my lord.
Okay. You can't have this.
11.
We'll take them to task. File, Mr. Deb. Where's Deb?
Just coming on. Lordship, I filed the rejoinder, yes.
Ready for hearing?
Maybe placed for hearing.
Posted for hearing.
Party submit appeals complete. Posted for hearing.
This is connected to item 12, Lordship.
12.
12 is already in the hearing list. Published.
Right.
16, hearing 16.
12 hearing order.
No, 11 and 12. 11 is order and 12 is the hearing pertaining to the same issue.
Number 12.
Very good, Mr. M.R. Marak, you record number 12, yes.
16.
My lord, this 16, the other connect.
John.
Yes, my lord, the other connected matters are adjourned, my lord. We did not make a mention of this, my lord. So.
Which connected matter?
The other connected matters is item
13,
number 14.
13, 14, 15.
Yes. 34. Only this was not mentioned because we are the petitioners. But anyway, my lord has been. My lord has already made clear that we will hear all these matters together. So, my lord.
Okay, list the matter together.
Together with us.
Item number 16 is together with item.
13, 14,
item 13, 14.
My lord.
Yeah.
My lord. All right.
18.
My lord, the short issue First contention is, my lord, I came across lordship has passed the order earlier also. The order passed by the one-member executive committee without, my lord, reference. May I just place it? It's not maintainable.
Yeah.
My lord, can you see lordship order?
Where's the impugned order?
Impugned order is
page number 5.
My lord.
No, this is not applicable here. No?
Page,
No.
Annexure 7, my lord, page number
You pointed out.
45.
The pre-amendment.
Like page 35, annexure 5.
Well, page 45.
Page 35, page 45, sorry.
Page 45 is the impugned order.
This issue is already dealt with. No?
Yes, sir. Yes.
Well,
Mr. Paul will send it back.
This I had satisfied, my lords, that this issue is not there, my lords. This is pre-amendment and post-amendment. I pointed out before, my lords, that this was an order pre-amendment.
Earlier. It is different.
Pardon about it.
So it's, in that event, my lords, I would pray your lordships give me some time. But I pointed out, my lords, that this is pre-amendment.
Pre-amendment of this act,
Maharam.
Here was the lordship order 16.5.
Because
as we related the rules.
Post-amendment, my lords, it is the requirement is of 2.
Para 3. Subsequent amendment is that they expressly provided subsequently.
Yes.
But prior to that also, lordship, can you see lordship order?
Which paragraph?
Para 2. My lord says, let us say counsel assisted by Sons for respondent number 1 and 2, when the matter has taken up today has fairly submitted, then on total examination of the material, especially the impugned order, the same seems to be without any authority and without any jurisdiction.
Jana?
Well, yes. You're reading Jana? Yes.
Paragraph?
Paragraph 3. And that refers to, my lord, Assam and Meghalaya Autonomous District Council, Rules 1951.
I pointed out, my lords, Rule 31.
This is not yet, my lord, please. Earlier, my lord, different judgment was.
My lords, if my learned friend wants to press this point, then I would pray, my lords, fix a date. Then I'd my lords, equip myself with the necessary law.
You're for the council?
No, my lords, I am for the private respondent. My friends for the district council.
You support the view taken by Mr. Paul?
At the moment,
you are the authority.
I'll have to see.
This, my lords, was raised by the first instance, if my lords recollect, and I had satisfied my lords that that would not come into play. Because here, my lords, what had happened is the issue was, my lords, that the matter went in political appeal.
Yes.
Against the political appeal, they went before the executive committee. So, my lords, that was the issue. On that context, we had placed the law before, my lords. If my learned friend wants to, my lords, press this judgment, then my lords may kindly give us some.
After 1 week, then.
Yes, be after a week.
Yes. On a prayer, this matter after a week.
My lord has directed the learned council, this council, to place a record also earlier.
The record is here. There are certain things I would like to show. I'll do it.
Yes.
What matter concerns what?
Lordship, this is the issue where they filed an application, my lords, trying to bring in additional documents.
Oh,
we pointed out, my lords,
before the
tribunal.
Executive committee.
Okay.
No, before the tribunal. And without hearing it, tribunal passed the order.
Tribunal says, well, we've given you opportunity, you brought documents on record, now you want to bring further documents on record, that will not permit. We pass an order to that effect.
Okay, we will examine it.
Yes.
My lord, here, my lord, we have filed one miscase. My lord, because there is a certain development which is very surprising, my lord. The bank all along had been maintaining, my lord, that there is a debit freeze insofar as my account is concerned. But a few days back, my lord, there has been a debit withdrawal from my account without my information whatsoever, my lord. There's been a debit, my lord, withdrawal of rupees 45,000.
How is this, Mr. Marpan?
Your Lordship, what happens is that I just spoke to the bank just now. In fact, the council in Guwahati, I just received one order. In fact, this was done in pursuance of an order passed by the Chief Judiciary. Just have a look, Your Lordship.
Well, the matter seized for report.
No, this is not at all connected to this.
And more interestingly, my lord, I fail to understand one thing, my lord. The Kerala police.
I just received this by.
It seems to have been done at the instance of Kerala police, my lord. And Kerala police has never participated in this proceeding before the Honorable Court. They chose to keep silent. Even, my lord,
are they active before CGM and got it?
Yes. There seems to be a bigger conspiracy, my lord, and even the, sorry to say, my lord, but even the officials of particular police my lord, state appears to be, my lord, in hand in gloves with.
So we've acted on basis of this order. So the account number of the petitioner would be the first page
was
itself,
through NEFT. It was
the
an
first
NEFT.
page where HDFC is mentioned in account number.
Where is this? Who's this Sindhu? Where is CGM?
This is in Kerala.
Iduki.
Yes. CGM. This is a name of person, Sindhu. The court where it's located is this place called Thodu Fuja or something. CGM.
But then the number of the petition, the name not here.
The name of the petitioner is here.
Number 5, yes, Killian
Yes.
Johnson.
So number 5.
And we are not here as an accused person, my lord. We do not even know who are the accused person in this case.
So when we
Whether
receive
he has
this
been
order-
apprehended.
Are you appearing in this matter?
No, my lord.
Then you're a party there.
Yes.
You get instructions. You have seen this one.
No, my lord, this order has just surfaced today only, my lord.
I just got it just now. As soon as I got this affidavit, I called them.
Give a copy to Sapa. He'll know what to do.
Very interesting, my lord. Here the Kerala police chooses not to appear before this
So we
honorable
pass
court.
orders in the main case.
Yes.
We list a missed case, now 180-2025, in WC number 48. This application has been filed by the writ petitioner regarding alleged unauthorized debit of rupees 45,500 from the petitioner's savings bank account. It is submitted by Mr. Thapa that the same has been done, even if the matter is seized by this court in the main writ petition, and also a debit freeze in operation over account. Stop. Mr. S. Marpan, learned counsel for the bank, has submitted that the same, as per verbal instructions, was due to an order passed by Chief Justice Magistrate. What is this? Thodu. What is Thodu?
THODU.
Yeah. THODU. PU. ZHA.
PU ZHA. It's in Kerala.
Which district in Kerala?
It's not mentioned here.
Iduki.
Uduki.
This is on top Office of Chief Justice Magistrate.
Yes.
Thirupata dated email. Thorus Kerala. Was due to an order passed by the Chief Justice Magistrate of Thodu Puza, THO, Kerala, dated 31/7/2025. Copy of the orders will be placed for this court. Like the applicant is not aware about the incident, about the said proceedings, copy of the order be supplied to the counsel of the applicant. This is a matter of further orders after 1 week. Yes.
Roger.
Madam.